Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and we are here. We are alive. Where the world is still occurring. And we're here for something a little bit special, different, whatever you want to call it. It doesn't really matter. We're here for better law review. That's what we're calling this this show style, which I am banking. This show style, we'll probably use it again in the near future. It's called Better Law Review, and this is where I catch one of my colleagues out in the wild, just willy-nilly streaming, thinking they have any business commenting on these trials or anything at all. And I go, oh, no, this isn't any good. That's not okay. We can't allow not goodness around here. We can't do that. It is just unacceptable. And so we will do Better Law Review, where we will watch the same thing. We're not, well, actually a little bit modified, because we're not going to watch what they're watching. We're going to watch them watch it. We're going to watch them watch it so that we can make sure and not only learn about what's going on, talk about what's going on and all that stuff, but we can also critique and make fun of the other person's analysis, all in good fun. Nothing, I mean, I think at least it's going to be fun for me. I don't know if it's going to be fun for anybody else, but this is about me. Like, that's what this is. It's about self-centered narcissism and all of that good stuff. So, I don't have time for any of this BS-itude from people whining about it. This is what we're doing today. And if you don't like it, maybe you need to check yourself into somewhere like a Holiday Inn or a Motel 6. Maybe that would help you get into a better headspace. I don't know. I don't know how to do any of that. I just know how to do this, I guess. Sharon Kovac, you're not the first person to ask, and you're not the first person to get this answer. No, I did not. I was not available when he auctioned it off on Sunday. I heard it was redonated, and it will be auctioned again, so I'll have another bite at the apple like a horse. So we'll see how that goes. Okay, guys, we have how do I word this? There I was, innocently, just enjoying my day, living my life as one does. And I was assaulted sensually. Wait, no. I don't think that's actually what I mean. My senses were assaulted. That's way different than being sensually assaulted, but both apply. I was sensually assaulted by Kurt. Kurt is watching, and has been for a while now, the Alex Murdaugh Supreme Court appeal. Alex Murdaugh, of course, was convicted of murdering his wife and child, his adult child, with a shotgun and anger and probably fentanyl. But there was a little bit of controversy. There's a little bit of controversy with with it because it turns out the court clerk was making statements that may have been inappropriate enough that she might have influenced the jury and deprived him of his right to a fair trial. And he is now looking to have a mistrial declared and either have the case, dropped or retried by the state. So that's pretty wild. It's gone all the way to the South Carolina Supreme Court. And that is what we are going to watch today is oral arguments, and it'll be fantastic. What was this? I saw a comment I want to hit real quick. Campsite says, Recato Law, any chance of reviewing this shooting in Canada? Well, not right now, but maybe later today or tomorrow or something. This is about Murdaugh. Will that Null guy come on your show if you bribe him with police body cam stuff? I don't want Null on my show at all. Null has destroyed his credibility like completely multiple times, and so I have no reason to bring him back on the show at all. Sorry. Bring back the good old days. Court ordered. No mad at the internet. No, there's no court order or anything like that. I just don't have any desire to have Null on the stream. So, but no. And why would I ply him with body cam footage? I don't want him on the stream, and I don't want him to have the body cam footage. So that none of that made sense. But a good chat. It was a good chat. I liked it. All right. So we're going to add this video from Uncivil Law in just a second. And we're going to jump right into this. It's been going for 3 hours. I don't know how much of that is because of Kurt pausing. But we are, we're going to at least start it and see what we've got. Who's it? Member for 2 months flexing that turgid member. Unsensual law. True. Also non-consensual law. I think both of those things are, I don't know what consensual law is. It's lawful law. I do know that. So Chrissy says, fine, Nick, ignore me. What did I miss? Chrissy? Murdaugh is guilty. Y'all are crazy. Is that the thing that I was ignoring or like avoiding? I just didn't see it. I'm sorry. I don't really, people's opinions about it don't really matter. The question in this is, does he deserve a new trial, whether you believe he's guilty or not? So just as a preface to this, I came up with this idea brilliantly today when I was, when I encountered Kurt's live stream and I noticed that he's retarded. Well, sorry, that wasn't diplomatically said. He's fucking retarded. And he has seemingly no idea like how, and this isn't surprising to me, but he doesn't seem to have any idea how the practice of law is accomplished. Kurt, whatever he may be, his whatever level of skill he has is that skill is pretty much to have some level of encyclopedic knowledge of Supreme Court cases. Like that's the main thing that Kurt brings to the table. He tends to know Supreme Court cases off the top of his head and facts about them and stuff like that. That's cool, I guess. It's always been kind of interesting to see his Supreme Court analysis. What he doesn't seem to know is the human side of the legal practice. He doesn't ever seem to understand why arguments are being made. And why people don't just get up there and recite a legal treatise and then, just ride the horse to victory or whatever it's called. So Kurt brings food to the table. No, Kurt brings food to the floor where his guests sit. So that's so yeah, I mean, long story short, that's what we're up to today is we're going to watch Kurt watch this legal argument, and we're going to listen to his commentary about it, and we're going to criticize it. Well, we being me, I don't care what you guys do. If you guys want to criticize it or not, is up to you. I will be doing that. I will be criticizing various aspects of it, and we'll also get to see the argument go. I will warn you that Kurt pauses a lot, and I'm going to try and not do that so much because, I want to get through this at some point this year. And if I'm pausing it constantly, and Kurt's pausing it, it'll take 7-8 hours. And I don't have that time today, and I don't think anybody does in their entire life. So we're gonna try this out, and we'll see how it goes. We may not finish, but we're gonna give it our damnedest. I do want to point out that we do have images available on Super Tips. So if you go to supertip.gg, which is pinned both in the Rumble and the YouTube chat, and it's also in the description of both of those videos. If you go to supertip.gg, you can send in a text tip like a super chat. You can send in a voice tip, which is where a super chat gets read by an AI generated voice, or you can send in an image, which is brand new. And those images, you get to, they go up on screen, and you're in control of that. Haven King says, are you mad because Kurt's shoulders are bigger than yours? No, Kurt's body generally is larger than mine. I don't have any problem with that. That's all, that's on him. So no. Miss Peachy Keen with one of the most important comments saying, looking snazzy. Thank you, Peachy. I hope you're doing really well. It's nice to see you in chat. As always, thanks for classing it up. Tits, yes. Yeah, he does have larger breasts than I do. That is true. It is true. We have a Kurt simp in chat already. Porkins, don't criticize Kurt. He has treated me well. He loosened the zip ties and fed me pizza casserole. Did you sleep for 2 days after that one? Is that what happened? Oh, see, here we go. Here's our first super tip with an image today. Looking kawaii today. Knicker. And that is, obviously, this is Femboy Ricada, which is just also known as Ricada. And that's the type of quality image content you are able to share on Ricada Law through the super tip system. Really, it is a remarkable piece of technology. Dirty Yankee 911 says, "Hey, F you, Nick. Sick effing suit. I hate you for it." Perfect. Mission accomplished. Mission accomplished. This is one of my new jackets. I mentioned the other day that I got 5 jackets. They were $40 a piece because it was end of the year sale. They're like $350 jackets, and they were on sale for $40 because they got new styles coming in for the new year, and they're clearing out inventory. This is one of them. It's nice. I do need to get it taken in just a hair in the waistline because it doesn't have. I tend to wear not for any real legitimate reason. I tend to wear like an athletic fit or a slim fit. And this is a regular fit jacket, so it does need to be taken in about an inch or two around the midsection. But you guys can't really see that, so right now it looks pretty good. Looks pretty good. Anyway, I'm really happy about that. So let's get going, I guess. So is that a Nicola Maxwell? They're in chat. Nicola, how you been, girl? I haven't seen you live in a while. Really happy to have you here. Nice to have you to join us. I'm glad. Let's see. Pants are not required. Pants are not only not required, they are actively discouraged. But a belt is recommended. So the belt, you want to have a nice belt with a rubber liner so that you can tuck your shirt into it so you get that nice tucked shirt look. Because if you just have a shirt wantonly hanging out and untucked like some sort of barbarian. It doesn't work. And unless your shirt tails are long enough to tuck all the way into your butthole, you need something. And so the belt is one way to do that. That is a pro tip. I do recommend it. Okay, let's do this. Let's do this. I apologize for the Kurt content. Not that we're covering Kurt. Like, I don't apologize for that in the slightest. I just apologize that you have to be exposed to Kurt. I do have the live chat up. I'm thinking of leaving it up, although I do want to point out that it is way ahead. They're they've been going at this for over 3 hours. And so their live chat is far beyond us. I also want to point out that we are already we're already surpassing Kurt in viewers right now, although we have an abysmally small audience. I don't think people are used to me being live during the day yet. So what I need you to do is I need you to all take a moment, go to your neighbors' houses, turn on all their devices, and log in with different YouTube accounts, and then make sure we need to pump those numbers up. So I need you to commit some crimes, breaking and entering, low-level hacking. These are mostly misdemeanors, depending on how you accomplish it. If there is, a family or a family member that is present in one of these houses in which you're doing this, the best option is to tie them up or use duct tape, for example. Tape them up, put them in an oven or a closet or something. You don't turn the oven on. You don't want to elevate this thing to murder, but it's a good idea to just get them out of the way. Just get them out of the way. Lenny Cran says, can you also tuck your wiener into the belt to make it look more elegant? And, some people know the answer to that question. Some people know the answer to that question. Some people have had to deal with that issue before in their life. And IYKYK, so to speak. So there we go. And most importantly, Kimby's Dirty Kitchen says, and give about 300 membership gifts. Yes, we are fully welcoming any memberships and and super chats and all that stuff. That we are open for business on that. We do have both memberships and super chats and super tips. We have all of them in stock. They were back ordered for a little bit, but they are here now. So there we go. So let's do this. Let's do this. This is the beginning. I've gone back to the beginning of the stream. Curtis has cool glasses on, so we know we are in for some good stuff.
Hello, everyone, and welcome to Uncivil Law, and I hope you're having a great day. For today's story, we're going to turn our attention...
Hello, everyone. Welcome to Uncivil Law. He never disappoints. Not once.
The appeal from Alex Murdaugh before the South Carolina Supreme Court. As you will recall, Alex Murdaugh...
Excuse me, Prince of Wales? Bono has not really let himself go. Actually, I'm just a good-looking Ringo Starr. I mean, for his age. Not in general, but like for the fact that he's 278 years old, he looks pretty good right now. But certainly not an ugly Bono. Don't do that to me. Don't do that to me. What is this? What? Come on.
Simply having a wonderful Christmas time. Simply having a wonderful Christmas time.
Whoever this
having
is.
A wonderful micro
I'm gonna come to your house.
Christmas was almost 2 months ago.
I am the Pokemon Slowpoke.
I'm going to come to your house, your school, your job, everything for the rest of your life. I'm going to come to your baptism. And once you are saved by the Lord, I will end you. I will end you in that moment. Fucking hate
was convicted of murder of his family at his estate.
That was good. We already
in South
have an ear
Carolina
pick.
using the shotgun.
There's a lot
So
of
it was sad.
opportunity on this stream.
Now, the evidence against him, to my
Please let me
mind,
know if
was
the
a little bit thinner
volume is balanced.
than I would ideally like.
I think I'm going to turn it up just a
The
little
evidence
bit.
And the timeline from the state was very compressed. It seemed implausible, not impossible, but it seemed a bit on the implausible side that it was Alex Murdaugh, given the time frames and given some of the situations. I didn't quite buy the state story, but that's neither here nor there because the jury convicted as they do. More to the point, however, for our
As
today's
they do.
purposes, is the clerk of court, Becky.
She would be a Becky, wouldn't she?
She might have done a little light jury interference. She might have done a little light talking to the jury and saying some things that the clerk of court shouldn't say. She might have done a little illegal. Well, Becky, for
Maybe.
her part, has had her case heard, and she's pled guilty and been disgraced and all the rest of it. She
So
wrote.
this is amazing, of course. Like, this is one of the key things about this is that the clerk who is accused of doing this has pled guilty to doing this. So we know that it happened. The question is, does this rise to the level of entitling someone to a retrial? I think it does. I think it does. I think it should. But we're going to hear the arguments about it. Lagging behind 32 months, a member, 32 months a slave. Speaking of chat, are you ever going to put your chat overlay on stream again? You took it off because of the YouTube strikes. I don't have any plans to do that. I don't have a particular reason. I mean, I guess like, so you can do like this. I don't know what, like well, it's not what I wanted to do. That was not it. No. I got this little chat overlay in the bottom right. I think it can be moved, but I don't know. Like, I don't know how valuable it is. I know the cool part about it is it does show Rumble and YouTube chats, and the Rumble chat I don't think is preserved because of racism or whatever. Literally. But I don't know. I don't currently have plans to do that. Plus, if I set that up, I have to actually find the right place on the screen to put it and everything. Let's see. Prince of Wales says, I will admit the J Riggings suit is snazzy. If anybody's curious, this is a lot of the shirts and jackets I wear are from a brand called Spazio. It's spelled Spazio, but I say Spazio to make myself feel better. It's a Turkish brand of, mostly they make really cool shirts, but they also do, they do jackets and they have women's clothing as well. Not as much women's clothing, which is how it should be. You women shouldn't be allowed to wear any clothing at all. That's just how life should be, and you should get over it. Like the Ferengi, the space Jews or whatever. But that's the brand of, YouTube has this feature that I should probably start taking advantage of. It just takes time, and I haven't gotten around to doing it, where you can actually put links to these stores, and people can actually shop at the places that, of things that appear in the video, which would be me. Like, you can buy me in Africa.
Wrote a book, which I bought, which she later had to recall because of plagiarism. Hilarious.
Okay, so Kurt's talking. I'm eventually going to stop pausing this, but I do see some people asking important questions. Haven King says, what exactly did Betty did to the jury? So Betty was the clerk of court. She's there in the courtroom, and helping facilitate the actual function of the court each day of the trial. And Becky, not Betty, Becky, she just made statements that aren't necessarily appropriate. For example, when it came out that Alex Murdaugh was going to testify at trial, she made a big deal out of it. She said, wow, she's the defendant's going to testify. That doesn't normally happen. She made these comments in the presence of the jury. She would say things, and we'll hear some of these comments, but she would say things like, "Oh, make sure you watch him and watch his movements and see if you believe him," and stuff like that. And now that's one level of thing. That's just completely improper for a clerk of court to be saying any of these things in the presence of the jury, because if you make them aware that something special is happening, they may be influenced one way or another in how they make their decisions, because they may be giving false import to something rather than looking at the facts that are being stated and looking at the credibility and assessing it for themselves, right? Like this is one of the issues that we have. So she made those statements, but importantly, she was planning to write a book about this trial. She knew it was going to be a big trial, and she was planning to write a book and then sell the book deal and use the proceeds of that. She said, according to her, to buy a lake house. She wanted a lake house, so she wanted to write the book. And she said specifically that a guilty verdict would be better for book sales. So we now have a staff of the court itself suggesting that there's a preferred outcome. That preferred outcome is detrimental to the defendant, which is important, but it would also be important if it was detrimental to the prosecution, and then making statements, which presumably those statements would be made in, in furtherance of that goal, which is a money-making scheme for herself. And so the idea is that she may have interfered with his ability to get a fair trial. Nana Bear 007 says, "Hi, Nick. I do want to point out that I have some nefarious purposes in keeping the chat up. I am noticing that there are people member chatting and joining Kurt's channel. And I think, of course, I am down for friendly competition if you guys are. And in the spirit of friendly competition, although I'm not going to count these because this is just kind of a little bit of a thing. I'm going to give out 5 gifted memberships to those on the stream, but I don't want to count those as part of the friendly competition that we're having with Kurt. So I just wanted to get some people going with some free memberships. Enjoy your month of my member. I really look, treat it nice, treat it well. If you get one of those, make sure you say thank you to YouTube, because I'm not in control of it. But that is something. So friendly competition. We will get, as soon as we get some members going on the stream, we'll put the banner up, and the banner is of course sponsored by Kurt's Dating Advice and Chicken Shop. And so like I said, I have a little bit of an uncouth purpose in all of this, in that I want to utilize the situation that we have here on the show to drive revenue, because because this is a sales job, baby. Poon Trigger's mom sent a super sticker. You can't really see it on this thing, but it's a flying pear, I believe. Thank you for that. And also, just as a reminder, if you don't want to send super stickers through YouTube, you can send images. What is this? Ryland Poole says, "In the embrace of the great Nurgle, I am no longer afraid, for with his pestilential favor, I have become that which I once most feared, death." So there you go. Papa Nurgle and his gifts have already made an appearance, and we know it's going to be a good stream any time that happens. I am the princess is true. She said, 3 months a member, says, "Ignoring locals chat. He hates us." I have not pulled it up just yet. Hi, fams. I see you guys now. Sorry. So I wasn't trying to ignore you. I'm just getting everything going here. And there we go. But yes, back to Kurt. And I will be very critical of Kurt in this, because You'll see. You'll
Yes.
see what happens.
And I still have the book though. So we may read portions of her book if we get bored during the oral argument. We'll see.
How are you going to
But
get bored
in any
during
event,
oral?
the South Carolina Supreme Court
already a man. You're going to get bored during oral? Okay,
has to
cool.
decide whether or not
Makes
Mr.
sense.
Murdaugh here gets a new trial. Now, I think the answer is no for a very technical reason, which, that's law, right? The problem is that his lawyer, Alex Murdaugh's lawyer, kind of blew it.
Thank you,
during
Lacey
the hearing.
P.
There was a hearing on
Thank
this
you.
issue. And the judge of that hearing was a former Chief Justice of the South Carolina Supreme Court. So, probably knows a little bit about what she's doing. And Alex kind of blew his play and screwed up the evidentiary record. And I think he's kind of SOL'd. At least based on that. That's what I think.
Smirky Kurt is a good Kurt. This is a type of Kurt I like, despite the fact that I think that he's despite the fact that I think he's completely ridiculous. His smirkiness makes me happy because that means that he's in a good spot. It means that he is in a good place. So we're gonna hope that he carries that energy.
I think he's kind of SOL'd because his lawyer screwed the plot. But maybe there's some legal issues beyond that, or some other issues, and we'll see what the South Carolina Supreme Court seems to think about the whole thing. So let's see what they have to say about it, and let's reassess our legal probabilities and see if there's legal issues that I'm not factoring into this equation. Let's see what we got.
Come on! Let's go, Kurt! Gah!
I missed that accent, baby.
Wait, what? So this is at the South Carolina Supreme Court.
I should see if I'm still eligible for bar admission in South Carolina. Maybe I
Why?
should just do it for the hell of it.
Why would you do that?
I do miss South Carolina. Great state.
Is it?
Good morning. Please be seated.
Please be seated. It's deep South.
The case for oral argument this morning, State versus Murdaugh. I believe the clerk of court, Ms. Howard, has already instructed to turn off your cell phones. If you have not, please do so.
This is why the U.S. Supreme Court just seizes your cell phone at the door. You can learn from others, man. On that.
So this is trying not to pause this so much, but I have to prep you for some of the features of this stream, really. And one of them is that Kurt is, he's a Supreme Court boy, Supreme Court of the United States, and he believes everything should function in that way. He doesn't understand the possibility of, states or anything else, anyone else having a different opinion than the vaunted 9 naked justices of the Supreme Court. He's going to be giggly as if Kurt practices before the Supreme Court because he watches them on the Supreme Court website, because he watches oral arguments all the time. And this is going to be a feature that is going to come through a lot. So I'm going to try and just comment on it one time. I think it's very, very silly and childish, and shows that Kurt doesn't seem to have a grasp on the human element of the practice of law. And that's really what this entire stream is about, is making fun of that. But you're going to hear a lot of that. So I just want to let you know and get you ready for that, so you're not taken off guard.
That one.
Courts in South Carolina are open, and we appreciate those who are present and here to observe, not participate. For those present who are not arguing in this case, please do not disrupt the proceedings. Any outburst or disruption will result in sanctions.
Thank you, Barbie World.
For contempt
Appreciate
of
that.
court.
Nice.
As we proceed with the argument, just want to notify counsel that on the primary
I stand through
argument,
your
as you
ban.
begin your 20-minute allotment,
Wow, he got RFK'd right in the right live. What kind of COVID did he get? So they're gonna do this way, and this is not how every court does this, but they're going to give you have 20 minutes to your oral argument. They're going to give them the first 5 minutes free. They're not going to interrupt them, which is you never, especially at the Court of Appeals. Alex Slayer says, "I love you, Daddy. I love you. Say it back. It back." Okay, thanks, Alex Slayer. I love you too. Welcome. Thank you for calling me Daddy and making me uncomfortable. I love it that as well. So when you go to the any appellate court, they can immediately jump in with questions. They get to control kind of your oral argument if they want to. They can just, but you also have to prepare in case they don't ask you a single thing to speak for 10, 15, 20 minutes, depending on where you are. So South Carolina is going to give you 20 minutes and they're going to give him 5 minutes right out the gate. And this is a cool thing because it allows you to set the tone of your own statement rather than letting the judges set the tone and direction of it. You set the tone and direction, the judges wait, and then they come in. And it gives you just this opportunity to freestyle on them. And you should also use profanity and racial slurs. Speaking of racial slurs, we have Gary the Holiest kicking open the gates with his member. I don't know if it's a kick, actually, if it's a member, but that's the first member of the stream. There we are. Straight out. Welcome. This is now we have the banner up. We have YouTube members. Locals members are available as well. We are fully stocked up on all memberships, super chats, and super tips. And you can find them typically on the back shelves if they're not up front in the promotional areas. You can find them back there. But all of those are available to you wherever you are most comfortable laundering money. That's what we want you to do.
5 minutes will be given without court
Thank you, Nana Bear.
interruption. So you'll have 5 minutes before.
I have to say that I don't know what to think about it, but it just strikes me as slightly amusing that they give all this like instruction. The Supreme Court of the United States doesn't do this.
Supreme Court doesn't do it.
It's like, okay, we're going to give you 20 minutes. It's 5. They don't do that. They're just like okay. It's all right, fine.
Yeah, the Supreme Court doesn't do that. They run their docket a little bit differently. But the Supreme Court of South Carolina does. And there's one really big reason, though. The Supreme Court of the United States has some permanence to it. Those justices sit on it for a long time. The rules don't really change all that much. They do go through rule changes, and they make major news stories. The South Carolina Supreme Court and other state Supreme Courts, they're a little bit more tumultuous. They have a little bit of a higher turnover rate. They don't have lifetime appointments. These are typically elected positions. And like all good positions, you rotate through them a little bit. And so with that, you get some rule changes and you get some other things. Kurt can't possibly fathom that this would happen, but it's nice. It's nice. Plus, again, this is one of the things that it made me want to do this stream. He doesn't understand humans. I'm pretty sure he's some sort of large lizard, or maybe an extraterrestrial. And by extraterrestrial, I mean he's extra. And he's like another terrestrial sized object. But he doesn't seem to get it. The Supreme Court of South Carolina knows that this is a case that will receive significant media attention, at least locally and also nationally. So they're going to explain their rules if for no other reason than that. I mean, this is getting media attention. He's called attention to the fact that they have open courts and that people are able to review them. They're not able to use their own cell phones, but there is a public recording. It's being done clearly by Law and Crime in this case, which is run by Dan Abrams, the original copyright cuck. And they know that this is national. Like Kurt just doesn't understand these things. Like this is very basic. Hey, we're going to have national attention on a court that a lot of people don't watch. And Everybody else doesn't know the rules. Plus, some of these lawyers may practice in other jurisdictions. I don't know. I know Dick Harpootlian is a, he's a big time South Carolina lawyer, but he may also practice in other states in the area. I'm not sure. Or if they're, if these lawyers are typically practicing in federal courts. I mean, they have different rules. So just tell them it's not a big deal. It's not a big deal. And Arian the vegetarian says, love you, my favorite douchebag member for 8 months. And I'm always happy to help out with any douche needs that are out there, both practically and by attitude. Anything you guys need, just, you can email me. Ready Red is a new member on YouTube joining at the paralegal level. Thank you, Ready Red. We have that puts us at two members, and now we have a party. One member, boring and vanilla. 2 members. Now we got some action happening.
No T.A. Bronca and Riqueta Femboy show when?
Why couldn't he pronounce Ty? No Ty Bronca. He said T.A. No T.A. Bronca. No Ty Bronca and Riqueta Femboy show when? I don't know. It was just proposed to me. I did, of course, accept the marriage proposal from Bronca. So I'll let you guys know as soon as we work that out. But it's something I have to make sure, with having someone else and doing a show together reliably, and not being like, oh, well, you're just a guest on my show, I'm just a guest on your show, but working together in a specific way, and I want to make sure that I'm able to make the commitment and then live up to it. And so once we get that worked out, I'll let you guys know.
Nick, first, snazzy jacket. Second, Kurt is unworthy of any woman with a Southern accent. That accent is basically easily liquid sex, and he is unworthy. Third, micropene.
I fully agree. Southern accents on women are a special thing to be cherished and treasured and feared. Thank you for that. And MQ Moss says, looking suave with your colored ties. Have you taken fashion advice from Shockit? No, the man doesn't stand a chance. I will put my tie game up against his all day.
We jump in with questions.
It's going to be tough, Chief.
And we'll have to show some restraint
So they
to
said,
do that.
We're not going to jump in for the first
At the end
minute,
of the
5
first
minutes.
issue,
The other guy
on
said,
the
don't be tough, Chief.
post-trial motion for a new trial based on alleged misconduct of the
thank
clerk
you.
of court.
There was a little light
Before we get
misconduct.
to the underlying trial evidentiary challenges in that matter, we will take a short break.
All right, so maybe there's multiple issues. Maybe there's some other issues beyond the clerk of court that we're appealing on, which,
Now we're
fair
gonna-
enough.
See, here we go.
If there are other issues from the trial
The
we're
tie
appealing on,
tone
then
should match
we'll try to
the
give-
jacket. Porkins, that's not entirely true. If you notice, though, there is coordinating accent threads on the jacket that match part of the tie's color pattern. And I'm on camera, so the tie needs to pop a little bit more than normal. In different settings, maybe you wouldn't wear something as bright, but we do have matching stitching accents that go with some of the orange in the tie itself. So I thought it was a little bit fun today.
give those their due. The clerk of court issue, I don't know if the
This is
South
true.
Carolina Supreme Court's going to save
This
your
is
ass on that one. We'll see.
And I believe, Mr.
You're welcome,
Harpootlian, you're
Kat.
going to handle the first issue.
It's Dick Poot.
We're ready to proceed.
I know.
Yes,
I know,
sir.
Porkins.
Good
thanks.
morning.
Good morning, and as I understand your instructions, I get 5 minutes without being interrupted.
That's right.
At the U.S. Supreme Court, I believe it's 2.
I'm mad that Kurt said Dick Poot. His name is Dick Harpootlian, and Dick Poot was the name I believe that I gave him during the live trial. You thief, you monster. But this is Dick Harpootlian. He was admitted to the South Carolina bar around the time Christ was being born. So he's been a lawyer for a very long time. And by all accounts, he did a pretty decent job. There were some misses, but he had a tough case. This was a very, very tough case. And he was also, I believe, a state senator or state House of Representatives member. I can't remember. But he's a political figure within the state. He has some connections. And frankly, with someone like Murdaugh, that's kind of it's a gambit, but that's maybe who you want. It's maybe who you want here. So anyway, we are getting into this 20 minutes. He's got 5 minutes free, and this is where Kurt really starts to lose me immediately. Lost score 23 says, glad to be able to actually interact with you instead of a day-old recording. Yeah, Lost Score, I am trying to increase my daytime presence as able. I might not always be able to do 3 to 6 hour shows during the day, but I am trying to get to the place where if I can't do a 3 hour show, we get, maybe we hit one daily topic for like an hour, hour and a half. I tend to be able to work that in. I've just been, like I said, I've been easing into this, right? We've been easing back into the whole streaming world. Speaking of easing in, Wrestler Town sneaking in the gates as a paralegal. Welcome to it. Please realize that you have just ruined your life a little bit by being here, and I am proud of you for making that decision. Thank you. We're up to 3 YouTube members for this stream.
And that was a nice ad, by the way. So I will give it to the.
What the hell is this? Chris Thompson sent floating heart for 10 jewels. I don't even know. I don't know what this what that is. But I do know that there's okay, so I've been waiting to see what this looks like. There's a gifting system on YouTube that involves these jewels. I don't know how they work. I just know that it's something I enabled. It's a way to participate in chat with the show, but I don't know what it does. So thank you, Chris Thompson. I'll report back on how that works. That's really cool of you. This is the first jewel gift on the channel, so I'm really looking forward to that. The Iceman says, "Sup, Nicker? Is this a new or old Kurt video?" This video is still live. He's live right now. We're just way behind. So this is today. This is right now. This is still happening. If we go up, he's well, he may be done now. He may be done now. I don't know, but or he's still talking. But this is from today, and this is not old. This is current, present. This is as fresh as it gets. This thing is young enough to be chained up to his radiator. Gen X Medic has gifted 5 memberships. I feel it starting. I feel the rumbling. I feel the rumble. We're up to 8 YouTube members. Thank you, Gen X Medic, for that. Hope you enjoyed your Harley ride.
When they changed the rules for that, because they did change the rules a couple years ago. It's like, we'll give you 2 minutes for free. That was a good rule change. Some of the other rule changes less so, but the 2 minute thing was good.
Katie B07.
This guy, there's only 20 minutes and they're giving him 5 minutes for free. Wow. Right? I mean,
what a gift.
That's a lot.
Wow.
Like the Supreme Court, it used to be 30 minutes, and then it was like, we'll give you 2 of them for free. These guys are like, 20 minutes, we'll give you 5 for free.
Who cares?
Okay. All right.
Wow. Well, first of all, I want to thank the court for, I know what has been a very diligent effort to wade through this record.
Are we going to run the clock
6-week
anytime?
Trial, and then a post-trial hearing that went a few days with additional, 2 hearings, I think, with additional record. So this is not a simple matter. But before I get to that, I want to just remark on this.
Okay, I can tell you right away, we're not at the U.S. Supreme Court. That's for damn sure.
No, we're in South Carolina.
Is this the way the South Carolina Supreme Court rolls?
Yes.
Because, I mean,
I love that he took the glasses off. And here we get to the, one of the first major instances. He does not understand why Dick Harpootlian is starting off his argument in this way. He has no concept of it. Kurt seems to believe, and I don't want to put words in his mouth or anything else, but he seems to believe that lawyers will stand up at oral argument and just recite legal treaties, and that will be the the scope of the argument. He's missing the fact that the legal questions and legal issues have been briefed, and he knows this. So this is frustrating. These issues have been briefed. This is an you're at oral argument. You're likely not going to change the court's mind, and you're probably not going to answer any major outstanding issues, but you might. They might have a question for you that is giving them some consternation, and they may want your opinion on it, and they may want the other attorney's opinion on it. They may just want to make a public statement about it, and they'll use a question to do so. There's all sorts of that, but this is your chance to relate this story and these issues to these judges, to appeal to whatever you think you need to appeal to for your client's benefit. This guy, Dick Harpootlian, has been doing this for 51 years. So for him to stand up and start conversing with these judges, he's likely practiced in front of damn near all of them at some point, or even if he hasn't, they're aware of his career and his antics and reputation. Leaning on that reputation is an obvious interpersonal rapport. He has 5 minutes to start building the sale, frankly. Fletcher Boy says, latest and gayest, don't judge me. You are judged. But he has 5 minutes to start this sale. He has 5 minutes to do anything. And so he's going to start by elucidating, a commitment to fairness in the criminal justice system, a commitment that they all made. Every single judge and lawyer in that room has made an oath to the Constitution, an oath to defendants and to clients, an oath to protect their rights, to zealously advocate for their rights, and to ensure, if nothing else, that they get a fair trial when accused of a criminal act. He's going to appeal right to that. Kurt doesn't understand this at all because of, I don't know. I don't want to say autism as like a joke or a throwaway line. I do think maybe it's some sort of spectrum issue where he just does not get these things. But it's really, really frustrating. And this is one of my biggest concerns with Kurt practicing law. Something that he has not really done is I don't think he understands this aspect of it. And I do think that if Kurt is going to legitimately enter the practice of law, that he would be better served with a partner who understands the human side a little bit better. And I think he could team up with someone and really do that well. And that's very common for lawyers to need some other person. For example, when I practiced law, it would have been very beneficial and helpful for me to fill in my weaknesses, which are looking to fly. No, I'm just kidding. I didn't dress as nice back then. That was a joke. No, one of my things that I struggled with is just dealing with the scheduling and organization of all of the minutia that you need to handle, which is why I liked handling smaller cases, because I was a solo practitioner. And I could certainly do it, like I'm able to do those things. It's just not a strength of mine. Had I kept practicing law on my own and or joining a firm, that would be one of the things that would have been a good complementary hire, either through a paralegal or a law partner that has a better focus on those things, which would allow me then to construct and deliver argument, which I was a little bit better at that sort of thing. I'm pretty good at research too, and I'm pretty good at drafting, but handling the mechanical aspects of the practice of law, not very fun. I don't really like it. And you guys know me. I like fun things the most.
What a great suit, Nick.
Thanks.
If I had a suit like that, I would have gotten off my charges.
I agree.
Also, you don't need to put anything in Kurt's mouth. He inhales whatever is in the vicinity.
Everything's in danger. Everything is in danger. Thank you, Ronnie O'Neill.
For my sensibilities, because I listened to U.S. Supreme Court oral arguments, this is awfully informal.
Thanks, Mark.
This is shockingly informal.
It's very informal. You're in the South, bro.
What the hell? And also the clock hasn't run. What is going on?
Oh my God.
This is madness.
How are they mad? This is mad. No, this is Sparta.
I would have thought that, the South Carolina Supreme Court might be a formal, stoic affair.
And again, this is someone who lived in South Carolina for several years, if I'm not mistaken, or North Carolina, but I believe it was South Carolina that Kurt lived in. It may have even been licensed in South Carolina, may still be I think he was, and then he's not now because he's in Texas, but he said he could renew it. You don't understand the South if you don't understand what's going on right now. The South is, and he lives in Texas. This is how it be. These are the good old boys. Like, make no mistake. Harpootlian is in the club. These judges, like I said, they know him. He knows them. These people all have reputations in this room. This is not always the case in the practice of law, but it's definitely the case in this case. And even Murdaugh, he's a legendary lawyer in that town, not for his acumen, but in his ability to bring in clients, possibly for money laundering and drug deals and murder. But, like, he was always able to land whales. But it has to do with this. It has to do with Harpootlian is doing here, with what Harpootlian is doing here. And it is a little bit of schmoozing. It's a little bit of networking and communication. It is humanity. Kurt's bad at anything that starts with Hugh. He is good at being a manatee. The Iceman, Kurt struggles to be interpersonal. Exactly. The fact that he can't understand jokes or someone ribbing him in his lives, he loses it. He can't see red herrings too. Correct. And again, it's one of my problems with.
And we're just having
my apprehensions
random
about his
introductions.
practice.
At this point, if Dick Harpootlian starts mentioning the Chief Justice's wife's peach pie cobbler, I will not be surprised.
That'd be fine. That'd be good.
This is a court hearing. I'm told. I have been informed that this is a court hearing. We're going to continue under that premise. This is a court hearing. All right, let's go with that.
I love his glasses. They're so much cooler than mine. Fuck.
As I came into this courtroom this morning, I'm reminded.
I always come in the courtroom.
That half a century ago.
What?
I sat right about there as Chief Justice Woodrow Lewis had us stand and hold our hands up.
What's happening right now?
As new members of the bar.
He has no idea.
What's happening?
All of us could fit in this room. That's how long ago that was.
Yeah.
But one of the things that impressed me that day was
again, 51 years ago, Harpootlian is admitted to the South Carolina bar. He remembers the chief judge. He remembers his oath. That's what's coming. This is human.
Oath. And part of that oath.
What are we doing right now?
We swore to uphold the Constitution.
He has no clue.
What is happening right now?
He's building rapport with judges. It's not complicated.
What are we doing? What's going on?
And as I stand here today, I'm honored to be arguing about how to interpret that Constitution, the Sixth Amendment specifically.
I wear kilts.
And in my opinion, I would suggest the Sixth Amendment may be the most important amendment because the First Amendment, which gives you the right to speak without government.
The Sixth Amendment is not the most important amendment, but this is a cool line of questioning. We all know the third is the most important amendment, and we know that because it has about the least decisions and is one of the least ambiguous amendments, and we don't have soldiers in our homes.
Interference with the Second Amendment, which gives you the right to carry a weapon or have a weapon without government interference, mean nothing without the right to a fair trial and a fair jury. So this matter we're discussing this morning,
I'm going to get a shotgun mic
fair
soon,
trial.
So there's just no mic in front of me.
A jury not poisoned by outside influences. I
You
would
guys
submit
don't
to
need to
you
know.
is 51 years ago as I stood there, I did not realize what I was swearing to do, but I do today. And that is to defend Alec Murdaugh's right to a fair trial. And I've got to admit, in the 51 years since then, I've never seen a factual pattern like this.
And here we go. Like that is a fantastic intro that Harpootlian just suavely dropped in there. 51 years ago, I made the same promise that every one of you has made in this courtroom. We all made it, and we all promised to uphold the rights of the accused. It's one of the most important things we do in this entire country. It's why the Sixth Amendment is so critical. And at the time I made that oath, I didn't realize what I would be doing today. Kurt didn't understand that line. Harpootlian kind of fumbled it a little bit, but he didn't understand he would be defending this guy under these circumstances. But he also comes in and says, and I've never seen a fact pattern like this. 5 decades of practice. He's never seen anything like this. And he's not talking about the case. He's not talking about the murder. He's talking about the murder of a fair trial by a court clerk who's ambitiously trying to write a book for her own profit and putting her finger on the scales of justice. And that is the story that he needs to sell to those old ass men on the bench. Kurt's like, what?
Where the clerk of court sets out to influence the verdict, to get a guilty verdict for financial gain. Now,
Well, I don't know if that was strictly speaking her motivation in the first
It literally
instance,
was.
to be
Yes,
fair.
that was her motivation.
Not that it really
That's what
matters
she
either
said.
way, to be honest. So
it does matter.
First of all, I'm not.
It doesn't legally matter necessarily. Well, no, it kind of does. It kind of does legally matter because, an improper purpose always helps. It always helps, especially if you are the accused and you're trying to overcome something. That improper purpose might be the finger on the scale in your favor, because judges have you have these standards of review in this, and there's going to be a little bit of discussion coming up about the standard of review and what they believe it should be. Harpootlian is going to take the harder road. He's going to say this is abuse of discretion and we've got it, which is a little bit tougher. Ideally, you would want a de novo review, which is where the appeals court reviews everything, the entire record, de novo from nothing. They look at the entire record that's before the appellate court, and then they go, okay, this is what has happened, and this is what we do. That's the kind of the lowest standard of review that the court does, and that's the place where you want to be. Harpootlian's actually going to take it a step further, although he's not going to say that it's definitely required to be abuse of discretion. He's going to argue that they have it, which is I'm previewing this. I'm previewing this because it matters, and I want you guys to catch it when it happens. But he's going to say that they have abuse of discretion, even though he doesn't believe that they need that. They've got it. And that's to cover the bases just in case these judges think, no, it is abuse of discretion. And frankly, he's going to lay out the case very well, that it's an abuse of discretion, that this judge went too far. But part of that abuse of discretion is to lay out the improper purpose. You need to tell them what about this discretion that was exercised by the judge was abusive. What about it is wrong? And the wrong thing is the fact that there is an obvious and notorious improper purpose, and the judge still ignored that, and then of course doesn't apply the law appropriately. But that improper purpose, this is all thematic in a story that's being built about a court that is unfair to a defendant. And every aspect of this court should be a little bit unfair, even if there's not an overt unfairness coming from the judge. And that's a very fine line you want to walk. As Kurt mentioned, the judge that handled the hearing is a former Chief Justice of the South Carolina Supreme Court. So this guy has a pretty good reputation, a little bit okay. All right. But, his abuse of discretion by him deferentially treating his clerk of court in her admittedly unlawful activity and suggesting that doesn't have any impact on the jurors, even though there's testimony from the jurors that they heard these things, that's going to become an important part of just an overall narrative. And that narrative building, again, is something you have to understand humanity a little bit. You have to understand story. You have to understand the spheres of influence. You have to understand that you have an internal sphere for your own internal conflict. And then you have an interpersonal sphere for the conflicts that you might have with others. And then you may have a group, a social group sphere and a community sphere, and then a city or statewide sphere, even national, global, universal, et cetera, et cetera, et cetera. And all of these spheres matter in storytelling. All of these spheres are relevant to where the conflicts arise and where the conflicts have potential resolutions. And going outside the spheres that you're dealing in for resolution is a gambit and doesn't tend to make sense. You need to resolve things logically. This is not life as much as it is storytelling. And if you want to hear more about like this, if you want to study up on this on your own, the book is called Story. It's by Robert McKee. There's a movie about it starring Nicolas Cage called Adaptation. I would strongly recommend both the book and the movie. They're really good. But understanding storytelling is something that not enough lawyers do. Kurt doesn't understand any of this. It's amazing to watch to me because my entire life is story. Every single moment as I look back is about getting to tell stories. It's about understanding how stories happen. It's about learning it and absorbing it and witnessing it and then living it in different ways. And to see someone who just doesn't get it at all is it's wild. Like it's interesting, but it's also kind of scary because again, remember this guy is supposed to be representing people.
Thanks for the Wednesday afternoon show. It's nice to watch live for once. The evidence will show Kurt's micro-peen doesn't understand human relationships.
White bread ass nigga.
Thank you. Thank you very much. Also true.
I keep losing respect for Kurt. It is utterly ridiculous how he misses this. Judges are human. Hitting them in their personal, moral, and ethical points of view, he is making them want to slap this down.
Yeah, exactly.
Not really sure that was the clerk's motivation. Second of all, you don't need to overplay your hand, right? You can just be like the clerk interfered, and that's bad.
No.
Juries shouldn't be tainted. Juries shouldn't be influenced by outside things.
This is the TISM. This is the sort of robotic and mechanical application of law, and this is not this is a criticism of Kurt. But again, lots of lawyers run into these sort of things. They don't understand this aspect of it. That's why they're not as specifically litigators. They do other legal roles, and they can litigate, of course. He doesn't get this at all, and it's the only thing I would say about this is nothing wrong with it. It's just that he needs to recognize that this is a weakness that he has, and he needs to partner up with someone who understands story, who understands humans, and who understands his relationship dynamics. Because he's like, why would you say that the clerk was trying to do this for financial gain? You could just say that the clerk made improper statements. Well, you can, of course, but it's way more dramatic. It's way more salacious. And also, most importantly, it's true. It's true that she made statements that is for financial gain specifically, which makes the purpose so impure that the court must step in because it is, it's a disgusting abuse for that to happen. I believe this live stream has now ended. I've noticed the chat is completely dead, and we down to 98 watching, which means that the show's over and the numbers just ticking down. So that being said, we'll no longer be in competition with the chat on anything. Well, unless I refresh it. If I refresh it and we pick up it, we'll go back to the chat as it was. But who cares? My petty game is thwarted. Cat Black says it's frightening to think Kurt has a law degree. Let me just go ahead and dispel that for you. Kurt is not especially ill-equipped or especially like whatever. He just thinks one way. There's nothing wrong with this. Of all my shitting on Kurt and joking on him and stuff like that, there is nothing wrong with the way that Kurt thinks about and understands the law. And there's a lot right about it. There's a lot of, if he's right, he's not always correct, but when he's right, the way he approaches law is fine. It's just about understanding where there are gaps. Every lawyer has them. No lawyer is independently like a superstar in all of these things. Well, there may be one or two out there, but who cares? Those guys are fucking nerds. And it's just about compensating by getting someone complimentary to fill up these what I'll call oversights.
They were influenced by an outside thing. And you could even step it up one step.
Correct.
And say it's particularly reprehensible in this case because it was a governmental official.
What a mistake that was.
And therefore, it's the government interfering with the jury.
It's funny.
So that's really bad. So interfering with juries is normally bad. And now it's the government interfering with the jury. And that's double bad. But you don't need to be like, and she was doing it for financial gain. That doesn't really.
She was doing it for financial gain. Yeah, that's a part of the story that matters. It's juicy.
This is fine. This is fine. It's okay, Kurt. I'm going to make it through, I swear.
I do want to go to the record fairly quickly and summarize it so that there's no misunderstandings. Rhonda McElveen, who's the Barnwell Clerk of Court, was asked by Becky Hill, the Carlton Clerk of Court, to assist her during the Murdaugh trial.
Here we go.
She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book because she needed a lake house. A guilty verdict would sell.
Right there. That's it. That motive. See, that goes beyond maybe misstatements. Maybe you can argue that Becky Hill made some misstatements that, she made excited utterances or something. And they may have been improper, but they didn't have an improper motive, and maybe the error wasn't so big. But this improper motive by the court itself, which means by the state of South Carolina, has impacted this guy's right to a fair trial. And that's the critical story for this is all you need to convey to the Supreme Court of South Carolina. This story needs to be revisited as much as possible and delivered to them. We have failed. Our system has failed, and here's why. It failed because someone wanted it to. Someone that we trust, someone that we hire to make sure that this doesn't happen. Their personal desires got in the way. That's the story. That's the juice that you squeeze out of the grapes.
That's a cute explanation for your knowledge of storytelling, Nick. But don't forget, you got your college degree in language arts. Hey, 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 hey.
I liked the laugh. Yeah, I got the college degree in language arts, but that was because, I already inherently studied it.
Sell more books.
And
That was
lazy.
said before December of 22. We didn't pick a jury.
Why does everyone in the courtroom have red hair?
Well, the Murdaugh family was red-haired monsters. And so it could be like a lot of these people are relatives and stuff like that. Like that could be the case. The other thing is there could just be redhead pride going on. Plus, we never, ever complain about redheaded women existing. Ever. So just shut your mouth, okay?
Until January of 23.
Iceman says the issue with Kurt.
The
Arrogance
best way
of
to
his
sell
behavior.
books was a guilty verdict. A guilty verdict would be better for the sale of books.
You're overplaying your hand, Dick.
So she explained she had a financial incentive for a guilty verdict. She also made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements. Identical to the statements that I'm going to read you in just a moment by the jurors as they were questioned. Juror P, on the day Mr. Murdaugh was taking the stand, Becky Hill made a comment, watch his body language. Juror.
I like this. I got to bring this up again. Luke Viano says, oh, hey, it's that cocaine lawyer guy. He's streaming again. And crazy. Now, I'll, of course, take this positively. But anyone who thinks that a lawyer and cocaine is a weird combination just isn't very versed in the practice of law and the legal profession. Lawyers and cocaine have a long and storied relationship. And while it was a time of my life and a period of my life that was very interesting and wild and crazy, it is over. But it's also really not that strange for a lawyer who dealt with some substance abuse issues. One of the highest, if not the highest rates of substance abuse of any profession in the United States is lawyers, for a whole bunch of reasons. Most of it probably just access and income of a lot of lawyers, but also stress and the type of material that you deal with and the type of people that you deal with. But now, I'm not saying that that's how I got it. Like, obviously, I wasn't really practicing at the time, so I'm not using that as an excuse for my own behavior. My own behavior was my choice. It's my choice. I have my reasons, but at the end of the day, the person making the choice is the one holding the bag, and you're getting arrested. But that being said, it's those are not the reasons that I did it. It's not the same sort of entry point, but it's just not that fucking weird either. So I don't know.
Nick,
what up?
Your streaming schedule is straight out of a stoned teenager's summer job at Taco Bell.
Bro, I know.
It's like if Taco Bell ran 24/7 on Mountain Dew and malpractice analysis.
Yes.
Keeping us hungry enough for that late night Crunch Wrap Supreme. That is the only thing we can look forward to save us from tomorrow. Keep slinging that unpredictable energy. Love the chaos. Never change, dude.
I only change in subtle ways. Don't really know how to change it.
Prior to Mr. Murdaugh's testimony, Juror X heard Becky Hill say words to the effect of, looks like the defendant's going to testify. This is an important day. This is an epic day. It's rare for a defendant to testify. Juror Z, watch his actions. Watch him closely.
This is a strange way to run a candy shop, people.
It's not a candy shop.
This is a very strange way to run a candy shop. We're talking a lot about the facts here, not as much about the law. This is a very, very strange way to run a candy shop. Is this how we do things in the South? I guess this must be how we do things in South Carolina.
Yeah.
I didn't know.
Again, this is a guy with 5 decades of practice experience. You certainly, anybody can criticize anybody for whatever, for perceived deficiency, etc. But you always should consider that someone with a vast amount of experience may have a plan. They may know what they're doing. And part of that plan may be that they don't have a better factual or legal scenario. So you go with the case that you got. But Harpootlian is certainly doing an okay job on this argument so far. Metal Mom, I wanted to bring this up because I think this is important. Just again, it pisses me off that some people want to keep bringing up your past. You don't live there anymore, but they sure want to put you back there. It's okay. It's okay. Like, the past did happen. It's real. Reality is real is one of my favorite expressions, because I don't think people, I don't think they grasp that. Reality is real. It did happen. It's okay. I'm not afraid of my past. I'm not embarrassed or ashamed. I don't live with regret. I don't like how some things worked out. Obviously, it didn't go as well as some things could. But at the same time, what am I going to do? Like, when you sit around and wallow in your decisions and your failures, you leave yourself in that place. And I don't have time for it. Ginger with a Soul, 4 months, says, I knew this is a good place to be a redhead. Oh, yeah, of course.
Oh, was that casual? Are we having a court hearing right now, or are we reminiscing, over drinks, I
don't think they have
after
drinks.
our golf game.
This is a court hearing.
I'm not sure.
In addition to that, Juror Z said,
and Nick Naylor, really triggering me here, taking all of my effort, says, who's your true love, Coke or EverQuest? I only wish that I could have tried playing EverQuest while on cocaine. Like, that would have been, just days and days and days. Like, no, it's good, guys. I'll camp this. I already kind of did that, but man, could you imagine with a stimulant? Holy shit. Ryland Poole says, does Kurt's rigid view complement trademark cases? Kurt doesn't litigate trademark cases. He was a basically a trademark approval. You would review trademark applications, make sure they were filled out correctly according to the rules, and he would then apply those rules to the application to see if a trademark would be granted. That was kind of his role there.
In an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's lawyers.
BTJ,
which she understood to mean Mr. Murdaugh would
pop over on Rumble.
would lie when he testified. And that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately before he testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741.
I can tell you this much for sure.
For sure.
Giving Dick Harpootlian 5 minutes for free was a mistake.
Why?
Yeah, you shouldn't have done that, South Carolina Supreme Court. That was a mistake.
Why?
Maybe don't do that again.
This is such a weird criticism. So Harpootlian what he did was he started off with some common understanding, some rapport, some principles, some vaunted legal principle, and now he's moved into the facts of the case. He's moved into this idea. We know that this woman said these things. So now he's setting the stage for those questions to come in, and he's setting the stage for his argument about why this is a violation of those principles that he laid out early. This is not bad speechery. This is not bad oratory, and this is not bad storytelling. Arian the Vegetarian says, I graduated college with honors. Nerd! But struggle with language arts so much that when I was homeschooling, my kids had to teach themselves the second half of Becca's 5th grade language arts. I applaud you. Hey, our brains our brains move in mysterious ways and different ways. Mine just happens to move that way. And a couple other fun ones. Solid member for 27 months, sharing membership with the chat. Says, how you handle the past is exactly how you should handle it. The past happened and you can't change that. In order to overcome what happened, you have to acknowledge it and not pretend as if it didn't. I agree. I agree.
Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told juror 741 Murdaugh was going to testify before he testified.
Do I believe in Jesus? Yeah.
That's what the jurors said under oath. That's what the clerk of court of Barnwell County said under oath. Judge Toll from the bench said at the conclusion of the hearing, asked the question, did Clerk of Court Hill make comments to any juror which expressed her opinion as to what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find the Clerk of Court is not completely credible as a witness.
Excellent analysis by Kurt, coming in from the side door. Ooh. And then letting that one go. He has to wait because what's about to happen is an introduction to the discussion about the rule that the judge allegedly violated with this line of questioning of these jurors. And Kurt's not going to understand the problem with it, but I am here to save you from it. Don't worry.
Ms. Hill was attracted by the siren call.
I was listening to this on the drive home. I picked up my daughter from her Spanish and music class. And I was like, hey, sweetheart, I'm sorry. I need to listen to this. I need to listen to Kurt talk about something because I'm gonna make fun of him later. And she goes, huh? She's 10. And I was like, yeah, I just need to listen to this. So I'm sorry. We normally listen to music in the car, obviously, like most normal people. But I was like, I got to listen to this because I'm doing a live stream on it later. So then she's sitting there and she is ripping Kurt apart the entire time. She's like, somebody turn off his microphone. This guy doesn't know what he's talking about. Kurt, get off the stream. I'm like, hey, yeah. Will you co-host? I need a second chair.
All of celebrity. She wanted to write a book.
But it's not just her credibility because the question wasn't just because if the juror had just been like, if Dick Harpootlian hadn't pooched this so much, then it would be he said, she said, right? And the clerk is not credible. So if Dick Harpootlian hadn't screwed this at the hearing.
Why am I talking like a preacher today? I don't think I'm doing that. I could add a little affectation to my voice. I don't. If I am, I'm sorry. It's probably just the Southern accents and my subtle love of the my Southern origin story. So I might just accidentally be kind of drifting into the Southern accent from time to time. And if I am, I never notice when that happens. It just
Right. Then this would be fine.
Peachy
But
says
he
aren't.
went too far. He made a mistake.
Thanks for that.
He undercut his entire thing. And so, yeah, the clerk of court is incredible. But unfortunately,
What up, Tugson?
unfortunately,
How you doing, girl?
you personally, Dick Harpootlian, basically elicited testimony to show that the juror wasn't influenced by that ultimately. So you kind of pooched that one, Dick. I watched it happen.
Kurt misunderstands something here. One of the issues that we're about to come up against is that the judge is not actually allowed to explore whether or not the jurors were influenced by the statements. And that's a weird thing for people, but I'm going to explain why, but I'm going to let Kurt fuck it up first. But don't worry, I got you.
About the trial and expressed that as early as November 22, long before the trial began.
My name.
She denies that this is so, but I find that she stated to the clerk of court,
The 5 minutes is up. Please, someone interrupt him.
Rhonda McElveen, and others her desire for a guilty verdict because it would sell books.
Someone ask a
She
question.
made comments about Murdaugh.
Here's a thought. Maybe someone should ask a legal question. That's what I mean, maybe we should start talking about the legal things that apply in this case.
Why?
This is a lot of facts.
Yep.
This is a lot of facts. You know what
Yes.
might be really
The
good?
legal principles are really simple, and he's missing this straight out the gate. The simplicity of the legal principle is you have a right to a fair trial, and he didn't get one. We don't really need to get into all of the legal nuance as to how we get there. It's pretty obvious. It's notorious and open on the face of the activities of the clerk and the statements. And why the fuck we aren't acknowledging that is what Harpootlian is trying to convey to the court. Fletcher Boy gifting 5 memberships. Thank you so much. That puts us at 13 members so far. This stream, 13 members. Now we're talking about a good Wednesday. But let's make tonight the weekend. I don't want to wait. 13 members. Thank you so much. Of course, the ticker and counter is brought to you by Kurt's Dating Advice and Chicken Shop. This handsome man is the model. This man is the model. This man is the guidebook, and this man is your Cliff's Notes to dating advice and chicken cookery. He is the man who, with the plan to bring your pan to your biggest fan, who's chained to the radiator. Kurt's Dating
You know
Advice.
what might be really good? At the Supreme Court of the state of South Carolina, you know what would be really good? Maybe someone should ask a question about the law.
Why?
Or maybe
Why
someone
are
at
you
some point should talk
questioning
about the law.
the judges?
That would be fantastic.
And again, the law has been briefed. And Kurt's like, well, why don't these justices do what I want? It's because they have different questions and concerns than you dope.
Anytime.
It's not even hard.
Anytime will be fine.
Which is a problem.
His demeanor as he testified, she made some of those comments before he testified to at least one and maybe more jurors. The clerk of court allowed public attention of the moment to overcome her duty.
Can we consider the egg juror's affidavit?
I'd like you to.
Well,
okay, I have to say, I don't know what I was expecting the first question from the bench to be, but can we look at the egg jurors' statements? Was not on my bingo card.
What up, Stringer Bell? Running those businesses.
in the record.
So this is amazing. So we have statements that are made by these jurors. Now, the problem with two of the statements, or two of the jurors, is one's an alternate and one lady is the egg juror. I don't remember precisely what happened, but I believe she was either an alternate juror or she was a juror, and she ended up with some issue that involved an egg, and she was out of the trial at that point. I don't think it was anything improper. It's just something happened. And maybe someone in the chat can correct me. My memory is fuzzy on the egg juror. I just remember something like that going on. But so of the three jurors who have made statements about Becky, that bitch, we have two of them whose decisions would not have influenced the case at all because they were, one was an alternate and one was dismissed out. So I don't know if she had like an egg allergy and got something for lunch. She had to go take care of her chickens. I'm not sure. But whatever it was. But we have two of those statements. So Kurt's like, why would he ask this question? I don't know what the first question was going to be. I don't know what I expected. But the first question is, can we look at the egg juror's statement? But notice what Harpootlian says. I hope you do. Because the egg juror's statement includes statements by Becky, that bitch, that were improper. And so if you want the Supreme Court to look at the egg juror's statement, you want that inclusion of her testimony. And you don't want to limit the testimony to, we got these people and these two wouldn't have influenced the outcome of the case. And the important thing is we're going to find out that doesn't matter. Rule 606B, which we're going to explore in a minute. It doesn't matter that specifically that they had no opportunity to influence the case, because there's all sorts of reasons that other jurors may not testify. And that doesn't mean that something didn't happen. It may just mean that they don't want to testify about it. It may just mean that they don't want to share this information. They don't want to get involved. They maybe don't remember things just right. And so they're not there. But that's not the question, because the question of influence is one that we're going to get to in a minute. But first, I have a problem. I have to go to the bathroom. I'll be right back. Wait, we're going to keep that up. I'll be right back. Don't worry. See you in just a second. Oh my goodness. I'm back. Sorry about that. Pressure queen.
Of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's correct. What her stated reason for was during the hearing. What was
So there we have an interesting conundrum, right? She did allow an alternate juror to testify, but she says that the egg lady's statement is not going to be included. And does that prejudice Alex Murdaugh? And it goes towards the overall narrative of prejudice. And sometimes you have to run something like this. You have to run unfairness as death by 1,000 cuts because there's not an overt specific act that is sufficient, but it's all these little things that point to unfairness. And of course, if you watch the Karen Reed trial, you saw Bev Cannoni attempting to do this the entire time. The entire time, Bev Cannoni is putting her finger on the scale in little places, and it amounted to what sure appeared to be unfairness against Karen Reed. And, ultimately, may have been part of the problem with, with the when people start to notice things like that and they notice the unfairness, maybe they vote against it. Fletcher Boy says depends fund. Yes, that is true. I will be wearing adult diapers, on my face very soon.
What's the rationale for her not allowing the egg juror to testify?
I don't know. Because as you point out, if juror 741.
Peachy, no, I did not wash my hands. Importantly, look, just for efficiency's sake, when you go to the bathroom, you just pee on your hands. You just do that, and then you shake them off, in the hallway on the way back to your office. That's
Was
why this keeps coming up.
to impeach Becky Hill's credibility. Now, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question is this, and I'm sure Mr. Waters will cover this. If the egg juror's testimony was just as theoretically impeaching as juror 70 or the alternate juror's testimony, 741.
Oh, damn it. I just missed it. Did you see that smirk?
Why wasn't the egg juror allowed to testify?
Exactly. Good question.
I'm not sure that she stated a coherent reason other than she wasn't going to.
Nailed it.
Remember now.
But she said,
Nailed it. Chief Judge says, okay, so if the alternate juror who is not going to be able to influence this case, if they're allowed to testify, why isn't the egg lady allowed to testify? Harpootlian says, no coherent reason. Don't know. Don't know why we had that happen, but that's what we did have happen, and it doesn't make sense. And again, it goes to the overall unfairness for Alex Murdaugh. And remember, part of this narrative is that this is a celebrity lawyer who simultaneously is a litigating legend, or well, at least a client acquiring legend in South Carolina for a long time. But he's also he's a bit of an enigma. He's a bit of an enemy. He's a bit of a rogue and a rapscallion. And that level of legal celebrity, if you think your reputation doesn't precede you into the courtroom, especially at his level of practice, of course it does. And so we start to get these questions. Why isn't he be given the opportunity to have this person testify about a fact that happened? Like, it's crazy. Why don't we allow this? What are we scared of?
What question is this? From I assume Chief Justice? What question is this?
Eggs to court,
why
which might
did
have
the
been
judge
why
allow?
she
I
was
don't know.
dismissed. He literally, he has no idea.
What?
Her statement, her testimony, her written statement, because she wasn't allowed to testify, and the judge says she wasn't going to consider that statement. Her statement contains statements that were improper. Bitch, Becky, you need to have her testimony. Like, you don't need to, but the inclusion of her testimony would have potentially impacted the original decision, which they're trying to overturn now, on whether or not a mistrial by the court because someone, and that's the reason, because like Harpootlian says, so she didn't have an intelligible reason. She just said we weren't going to do it. Looks unfair.
I thought I understood how law worked. I really did, guys.
You don't. I've been trying to tell you.
I thought I understood how law worked. You
have
I went to law school.
fucking idea.
I've been a lawyer
It's
for
so
almost 20
irritating.
years, and I've read thousands and thousands and thousands of cases. I thought I understood how law worked.
Have you stood in front of a judge and argued a goddamn thing? At least on behalf of someone else. I mean, I think you may have on behalf of yourself, but on behalf of someone else, have you ever done it? Like, have you ever gone, Judge, like, what are we doing here? What are we doing? I had a bank turn off the power on someone who was staying over. They had stayed over past their foreclosure and then the 6-month redemption period, and they were significantly into basically just squatting in this house. But it's the house that they'd lived in for a couple decades. But the bank had foreclosed on it. They probably shouldn't have been living there, but the bank knew that she was living there. She was elderly, and they turned the power off in the winter. And my client fell down the stairs, and suddenly we had a really strong negotiating position. Because the question is, Judge, we're figuring this out. Like, there are all sorts of ways they could get her out of the house. But one thing they can't do is a constructive eviction in Minnesota in the fall and the winter. Like, you can't do that because it's cold out. It's cold out. And then that turning off of the electricity, that led to an injury. Why did we do this? Why is this the way the bank is handling this? Doesn't the bank have the resources to use the courts to request assistance from the sheriff, et cetera? No, instead they went to the electric company and shut off an old woman's power. Dumb. But you can't just go in and be like, well, here's the principles as to why. He's a judge. What are they doing? Why, in God's name, is a bank with millions of dollars who's been foreclosing on this property for now 1.5 years already? Why are they shutting off the power? Why aren't they going through any of the proper legal channels? They're past the redemption period. She should have been out of the house. She wasn't. But the bank didn't do anything to get her out of the house. They didn't go through any of the proper channels to do so. They had sent a bunch of paperwork, but I guess you just ignore it. Now I pick up the case, 1.5 years into this. Like, I'm not there at the start. I'm not there for the foreclosure. I'm there to try and help this woman navigate the fact that she is going to lose her house one way or another. Or maybe we could keep it, but it was a long shot, But the bank did a bad thing. And suddenly we had a lot of leverage because the potential damages would have probably been tripled. And maybe some punitive damages could have been added if she would have gone for a full lawsuit. But she didn't, that wasn't her goal. That wasn't what she needed. And that would have been a bit of a stretch. But the bank shouldn't have acted that way. And part of that was going into the hearing and saying, hey, Judge, this is what happened. The bank had no business doing this. And now my client's got an injury. But it's about that story. Like if I just wrote up a thing about, oh, you can't shut. Well, who cares? Yeah. So it matters that she fell down the stairs, though.
I have no idea what's happening right now.
We know.
Said her affidavit is in the record, so we know what she said, Ms. Hill said,
Right.
and we now know what Ms. Hill said she didn't say.
Yes.
So I take that to mean that it was considered. The egg juror's affidavit was considered by the court, and we can consider it.
In our defense, when you look at the record, remember, we were
So yeah, that was the whole purpose of that question was for the court to justify its own consideration of this thing. And that's what Harpootlian wants. That was a good win. 200 Watt Studio says, what happened to Kurt? You were his biggest cheerleader a long time ago. He is not entertaining. Well, that's one of the problems. The other problems are myriad, and we don't need to get into them here. This is all good fun. The thing that happened with me and Kurt, just a very quick summary, was during my troubles. We had some personal disagreements. I was frustrated with those. And as a result of that, I started watching some of Kurt's content. People sent me stuff, and then I started watching it, and I realized what had been going on the whole time, and I figured out that there was a much better way to deal with Kurt, and so I removed myself as his friend. I don't hate him. I don't want anything particularly bad to happen to him, but I do now watch him as if he's an anonymous person on YouTube, and I find it to be one of the best shows that exists. I find it very, very entertaining, but for completely different reasons than I think he intends. World Radio says, recenter your YouTube vertical, shoulders and air. Oh, yeah, I guess I have to get like way over here to do that. That's the one thing about the YouTube vertical streaming is I'm not in control of where that is necessarily. Let me see what it looks like right now. If it'll ever get there. Who knows? Who knows? But thank you for the reminder. I don't know that there's too much I can do. We do have, I did not update the YouTube members. Oh wait, no, I forgot. 5 of those were from me, and they were the free ones. Yeah, I don't really have, I can't get too much different, and I can't change how YouTube cuts that. So I apologize. I don't have, I need to figure out a little bit of a better option for this, but we'll do it at some point. We'll do this at some point. It's very uncomfortable to sit where I was right then. All right, back to this.
Examine anyone under Judge Toll's initial order.
Let's see if I can do it.
And then it was a moving target. Then it was going to be some that were going to be examined. We weren't going to be allowed to examine. Then we were allowed to examine. So it was an evolving process. If she in fact considered the egg lady's affidavit, she did not cite it in her order. Just as she did not cite Juror Z or 741's statements about do not be fooled, comments about how the attorneys are going to try to
The state
deceive.
argues in its brief that Judge Toll, in making specific finding as to certain things jurors did say, was an implicit rejection of the other statements the jurors said Ms. Hill made.
Yeah.
What's your response to that?
Well, I would say that's wholly unsupported by the record.
Hooey.
I mean, a judge in an order is going to say what they considered, and they should say what they didn't consider and why. This implicitly, I mean, the statements by 741, by Juror Z, and by the egg lady all had bearing on Clerk Hill's credibility and what happened. It's critical. And let me say this also. Even if you didn't have what they said, if a judge, as the jury came in on the day Mr. Murdaugh was going to testify, said, it's an important day, it's an epic day, you better watch how he testifies.
Yeah, you better
It doesn't
watch it.
say that about any other witness, except some sort of charge at the end of the case or maybe before, but specifically points that out.
Mr. Harpootlian, let me ask you this. Judge Toll placed the burden on your client to prove prejudice in this case.
Yeah.
Does Green establish, in a case with external influence on a jury, a different standard and burden of proof than...
Oh my God, it's actually a legal question.
Maybe that'll help with the...
I forgot what those sounded like for a while. Yeah, that sounds like a legal question. Hey, there's this case, Green. Does it set a different legal standard? That sounds like a legal question. Wow.
Is that a legal question? It's cool.
I'm here for it.
Yeah, me too.
And the Fourth Circuit jurisprudence.
No, it does not. It's consistent with Rimmer. All Green says is we're not going to go through this burden shifting or any of this until we determine whether the statement was inconsequential. I say inconsequential or consequential. And if it is inconsequential, we're not going to go through this analysis. That's all it said. And I'd point out in Green, the process used by Judge Toll of calling all the witnesses up and asking them if it had any influence. Judge Hill, in a footnote in the Court of Appeals.
Chris Onion says, is he saying egg juror or is it an accent? It was egg juror. There was something like she brought eggs to the court or something like that. It ended up getting her dismissed out as an alternate juror or something like that. I don't remember the exact.
Green decision points out that 606B, he says it's not raised in this case, but, should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So.
Well, in this context, yes, that was the entire point. I don't understand what we're trying. What are we talking? What are you asking about?
We know you don't get it.
Your complaint is specifically that the jury's verdict was corrupted by an external influence, namely the clerk of court saying some bullshit, which she definitely said.
Yes.
She definitely did those things.
She did say
and
it.
She carpooled with the jurors and did some other bullshit. So your complaint is
she carpooled with the jurors. Like the amount of corruption just casually dropped in this is insane. Is insane. It just drives me crazy. Oh my gosh. Okay, here we go.
The verdict was corrupt because the clerk of court, who's a government official, saying and doing some bullshit that corrupted the verdict. So, and now your question is, should the judge in the hearing on that issue, should the judge ask any questions about the verdict?
No.
I mean,
no.
Yeah?
No.
I mean,
why are you bad at this? How do you not understand?
Seems.
No. There's a rule on this for a reason, but let me just explain it real quick. People are really bad at assessing what influenced them. People are not good at it. They cannot figure out what actually influenced them or why. Also, sometimes their opinions change. So if you have jurors who heard these statements and then the trial's over and they research the trial a little bit, they're like, oh, okay, so what was this about? And they go, oh my God, that guy's a scumbag. They may have been influenced, but they may not want to say it. That's why it's improper to poll the jury about whether or not they were influenced. One, they don't know. People are notoriously bad at these types of things. They don't understand. So that's your first issue. Your second issue is that they may have motives to say they weren't influenced. And it doesn't matter if they were or weren't, in their opinion, influenced. Because anybody who knows anything about psychology or sociology or anthropology understands that the way humans absorb information and process it is not always conscious and sometimes runs contradictory to their own opinions. And that's a really important thing. And so if you're sitting there asking them what the answer is, and they have motivations maybe to give you a specific answer that's different than the truth, or just at the basic level, they don't know it. They're not good at it. People are not good at understanding this. If you wake up in the morning and you see 5 different cereal boxes, tell me which one of those had some influence on what you ate for dinner. And you may say none of them, but how do you know? How do you know? Your brain just processes this shit all the time. So the questions that the court is limited to are questions of whether or not a statement was made that was improper, that was in the presence of the jury, not whether or not the jury self-assesses its own influence, because they suck at it.
Seems like okay.
Yeah, he has no idea. No idea what's going on there. What is this picture? I don't know what this picture is, but I like it. Thank you for that, Anonymous.
Yeah, I mean, it sounds like, yeah.
Well, that's an interesting point because Rule 606B says that you can't consider the effect of something on jurors because otherwise you're invading the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladden.
Kurt, if he was healthy, that's who Kurt looks up to. Who is that?
Where a deputy says he's an evil fellow and, he's guilty.
Is it just AI Kurt?
They say
it's fucking funny.
You can't rebut that. That's not rebuttable. And so he gets a new trial.
I like to touch your
But in
rebuttable.
Parker versus Gladden, they talked about the prejudice.
Well, it's the prejudice is apparent. If you use the standard some of these cases use, which is the hypothetical juror, would it objectively influence the hypothetical juror? I mean, I think that's what the state has to do is say these comments would not affect the hypothetical juror.
But in your
right, so the state has to make the case that the comments are proper, that they're not that they're not sufficiently improper, but they don't have to make the case that they didn't affect someone. They have to make the case that they wouldn't affect someone who doesn't exist. Again, a reasonable person standard, a hypothetical juror, a similarly situated person, because how it impacted the juror it's not discernible, and it won't be honest, and it's not useful. Did these statements get made? Were they audible to any jurors at all? And could a hypothetical juror be influenced by these statements? And I think very obviously in this case, we have a bunch of yeses right there.
Brief, you also say that the presumption ought to be irrebuttable. Are you standing by that here today? Or are you wanting?
Oh my God. Some of these guys are so old. This guy dug the pit to Hades.
Us to follow Rimmer and Parker and say it is rebuttable, but you have to use the objective standard on an average juror in considering the effect.
I'm not sure what the difference would be practically.
Yeah,
well,
you're not sure about anything.
It is. I would concede that it should be rebuttable, but in a situation like Parker versus Gladden, I don't know how you rebut it. I mean, it may just be it's rebuttable, but there may not be any way to rebut it. So
in some circumstances, the conduct can be so reprehensible and egregious, it becomes a de facto structural error.
Okay.
Well, I read your opinion.
That was I like that. That's the right. That's a good legal question. I like.
Okay, so Kurt is now caught up. The judge basically he says that there's if they can't rebut the presumption, then what we have is effectively I don't know exactly how he worded it, but a structural problem with the case, and that means that there is an open, notorious problem with how the case proceeded. It's patent. It's on the face of it. It's in the front, and it's not a mystery. And we don't need to assess whether or not there was some specific influence here or there, if the influence was sufficient, because we know that the structure of the case is compromised. It's like the foundation of a building not existing. And that's the issue. So that judge just lays it out really simply. Now Kurt's like, oh, okay, I got it. Now it's like, yeah, we got it. You're not following any of this.
Like that. See, that's a good legal question, right? So when you talk about structural error, right? So now you kind of move out of the idea of the witness, what happened to these particular jurors being the thing, right?
Emmanuel,
it's basically, it corrupts the structure of
I think
it.
he deserves a new trial.
It fundamentally breaks the structure of the trial. And so you don't really need to get into the nitty gritty of how it did or didn't influence the jury because it's structural. And so that's a good legal question. I'm like, okay.
That wasn't a legal question. It was a legal statement. He just explained what was going on.
Maybe it's a structural error. That makes sense. And then you don't need to worry about its influence on the jury because it's just structural at that point.
Because it's also unknowable. It's unknowable what the influence on the jury would be. There's no way you can figure out how any of this stuff influenced a juror. It's impossible.
Okay, you could do that. That makes sense. I'm here for it. All right, let's go.
Court of Appeals on structural error, where the judge refused to let the defendant testify in a death penalty case. And I've digested, or as my wife would say,
that sounds like a structural error.
Yeah.
That sounds like a structural error.
But in the same way,
the defendant wants to testify.
The court itself influencing jurors is a structural error.
Problem. What judge made that decision? Oh, Lord.
Oh, wait a minute.
Digested, not digest.
Miss Peachy Keen says it always sounds like there's a sausage stuck in his father's throat. Wait, who are you talking about?
Digested, I'm sorry. That case and the structural error analysis. And I must say,
talking about?
Mr. Griffin and Mr. Barber and I have had a significant discussion on whether that would be structural error as opposed to not letting a defendant testify in a death penalty case. It could be, but I don't think we need to go there for this opinion, for this case. I think the clerk of court tells everybody that'll listen, I need a guilty verdict. She tells everybody, so I can make money. She tells everybody, so I can buy a lake house.
Don't worry.
And then she proceeds to talk to jurors, not...
Peachy, ICE is on the way. I'm going to need you to get into an SUV and just wait.
I mean, maybe my memory is failing me, but I don't remember any of that. I don't remember any of that from the hearing. It's been a while. I know it's been a hot minute, but I don't remember any testimony.
Well, part of the problem is that not all the testimony at the hearing was allowed. So that's, and some of the testimony came in through statements that are, asserted that those should have been part of the record.
At least in the hearing that I remember, about her saying, I'm doing it for the lake house. I don't remember that. Maybe okay.
Not about inconsequential things, but focus on how to view the defendant's testimony, and to juror Z and to juror 741 into the egg lady. Don't believe him. Don't believe his lawyers. I mean, I submit more than
it's like a memento. Don't believe his lies. Teddy, don't believe his lies.
Than enough to meet the Parker versus Gladden standard, or the Cameron standard, or I think it's Bennett, the case we looked at. I just looked at yesterday.
This is still not a real legal hearing, though.
All of those are cases in which there's no question what was said wasn't inconsequential, wasn't neutral. It was an effect to influence.
Is it a finding of fact or
$5 from J. McCarthy World? I had no idea Poot was allowed to be a appellate lawyer too. This is wild. Yeah, there's no rule against that, and it's not unheard of or uncommon. A lot of lawyers specialize in one or the other, but some lawyers.
I'm about to once I get a good reference point, I'm gonna refresh this, and we're gonna go right back to this. But I want to see the chat as it was happening, since we've got it pulled up.
So it is not unheard of for a lawyer to be the trial lawyer and appellate counsel, especially where issues not concerning the lawyer's competence are at issue. So yeah, that's not unusual. So yeah, he's running this case all the way through from beginning to end. Okie doke. That's fine. Thanks for the super chat.
conclusion of law by Judge Toll, where she wrote on page 31 of the record, this court further finds that the improper comments made by Clerk Hill
Pro engineer,
were
I did
limited
see
in
it. Thank you.
subject and not overt as
Much
to
appreciated.
opinion. I know you say that language was put in there by the state in its proposed order. I don't want to talk about that because she signed the order. But it is her finding that the statements were limited in subject and not overt as to an opinion, a conclusion of fact or law?
That's a
Sounds
conclusion
like a
of
legal
fact,
conclusion.
which gives rise to a conclusion of law. But that statement is wholly unsupported by.
I think it's a mistake, Dick. I mean, based to me, I mean, you've been thinking about the issue longer, so maybe I'm missing it.
You are. Oh my gosh. Aaron Troyer says, here's $5 to bribe you to do the Bronco Ricada based AF law show. Sounds good. $10,000 more and the bribe will be ready. No, I'm just kidding, of course. Yeah, I just got to work it out with Bronca.
To me, that sounds like a law, and you want to be an issue of law because the standard is better for you, right? Because if what that judge said is legal, then de novo, then great.
This is where Kurt is missing out on something I mentioned earlier. Kurt is arguing that you want to get your de novo standard of review. Harpootlian is saying we've reached abuse of discretion. Harpootlian is saying we don't know if abuse of discretion is the right standard, but we're there. We're there anyway, which is a strong argument. Psychologically, it shouldn't be, but it just is. It's the idea of like, wow, the expected lawyerly argument is for de novo review. And he just breezes right past that. He's like, it might be de novo, but really it's probably abuse of discretion. And we have it. We have abuse of discretion here because we have all the, and Kurt, of course, if you saw at the beginning, Kurt's like, why is he arguing facts? Why is he doing that? He should be arguing law. He should be doing that. He should be arguing law, not facts. Facts are bad. Facts are bad because facts are going to get you to abuse of discretion instead of de novo. Yeah, he doesn't care because the facts are that bad. The facts are that bad. And the facts lead to the conclusion that some fuckery occurred and the judge just kind of ignores it. And the harm that's done by the judge ignoring that abuse of discretion prevented a fair trial. That's the argument, that's the argument here. And it's a good one. It's a good argument.
Right. So wouldn't you want it to be legal? And so it's like, oh, the judge, what she wrote was a legal conclusion. Therefore, it's a de novo review. Therefore, you can just do whatever the hell you want.
You might want that anyway, but you go with what you got, not with what you want.
As opposed to, it's a factual conclusion. If it's a factual conclusion that leads to a legal conclusion, but it's a factual conclusion, that's not really good for you, Dick. Am I missing something? I don't know, man.
Yeah, how to argue.
I don't know, man. This is strange. Okay.
The record. And I would submit an abuse of discretion.
If you're trying to do this on an abuse of discretion analysis, you're having a bad day.
Why?
Particularly because it's a former Chief Justice of the South Carolina Supreme Court.
This is a genetic fallacy. Oh, he couldn't have abused discretion because he was good at being a judge at some point. Who fucking cares? Judges abuse discretion all the time at all levels of judgeship. It's not like it's personal, typically speaking, when there's an abuse of discretion. It's not like you're saying, oh, this judge is a scumbag. You're just saying that the judge had discretion here and they abused it. They overstepped their discretionary authority and they made a decision that runs flatly against the facts and the law. Like, that's it. That's all you're doing. It's fairly neutral. Judges make tons and tons and tons of decisions every single day and they get some of them wrong and they get overturned on appeal and they get overturned on abuse of discretion. There's nothing particularly bad about it. I was in an argument with someone once and they were taking personal umbrage to the fact that I was saying, well, you're not correct. You're not correct. And they're like, stop telling me I'm wrong. And I'm like, well, sometimes someone's just wrong. Like, it's not personal. Like, you're just either correct about like a fact or could be a law or a statute. Like, it wasn't in this context. It was just a regular discussion, not a legal discussion, but it's like, you got something wrong, like a date, a location, people who are present, things like that. It's like, well, it's neutral that you're wrong here. Like, it's just, but like, that didn't happen that way. So like, we now need to figure out what did happen. It's like, well, stop telling me I'm wrong. Sometimes you're just wrong. And sometimes judges just abuse discretion. And sometimes, sometimes they can pass strict scrutiny, for example. And sometimes they can't pass rational basis. And so it's like, oh, you're always legally maneuvering into the most advantageous position. That's what Kurt is stuck on here because that's what they talk about in law school. But sometimes you just have the thing and you don't have the other thing. They've got abuse of discretion, I think. It looks like it. Now, the Supreme Court can always disagree, but it kind of looks like they got abuse of discretion here because they have a bunch of shit happening that, again, prejudices Alex Murdaugh. Let's see. Lynn Britton says, Kurt didn't read my super chat. Maybe you will. Missed you. Member for 2 months. Lynn, I will read your super chat, of course. If I saw your non-super chat, I might read it too, but like, I'm not always looking at that.
So an abuse of
area
discretion analysis
of my
isn't
screen.
easy normally because judges get a lot of latitude. But this isn't just any judge. It's a former Chief Justice.
Who cares?
And you want to say the former Chief Justice abused her discretion? That's what you want to go in with? I don't know about that one, man. I don't know, man. That sounds like That sounds like a rough play to me.
What up? What? You're muted, right? I'm not muted yet. Just a second. Hold on. I'll be right back. Sorry about that, guys. That's my daughter asking me a question.
Wouldn't it be better if it was just a legal standard? I don't know, man.
And how about her finding that those comments were cured by Judge Newman's overall?
Lolita smiles. I think Kurt's, like my sunglasses are just sunglasses. I think his sunglasses are blue blockers, where they specifically block blue light and they help with, reducing eye strain. I mean, for me, I don't know. Maybe I could do that. Maybe that would be overall better. But I prefer the look of different eyewear. I don't know if I want the one he's wearing. It's kind of weird. Lady Tammy says, was it a good question? Lady Tammy, she asked me if I would show something that she made on the stream. So she's going to go get it. I think you guys might laugh.
All jury instruction
But I don't
that
know.
the verdict was to be based on the evidence presented and the law as he gave it and not on anything else.
Well,
MK
they would never
Ultra.
have, as long as the judge gave the appropriate charge at the end of the case, you'd never have a case of jury tampering.
This is a great argument by Harpootlian because basically one of the counter arguments to all this is that, the clerk of court said all this stuff, but the judge gave a curative instruction. We've seen curative instructions in criminal cases that we've watched on this channel multiple times, where the judge says, ignore that, jury, don't worry about the clerk saying all this stuff that you have been thinking about for now like 4 weeks. Don't worry about that because I'm going to tell you that you need to make your decision based on not that. And you can't do that. Human minds don't work that way. We don't have a way to consciously filter out every single influence of everything. And we don't want to either. Juries are not robots. Juries are humans. But when you have something prejudicial, when you have something that could influence that hypothetical juror, when you have that occur, and especially when it's, at the behest of the court clerk and therefore the court and the state itself, you got to try it over. You got to start it over.
You could have somebody bribing a juror, and according to her reasoning, they I took the money, but I'm not going to do what I said I'd do. I mean, it's. I don't believe.
Yeah, and his point here is like, well, you could accept a bribe and get a curative instruction that says don't be influenced by the bribe. Or I think. I don't know if he's given the example yet. He's about to, if he hasn't. It's what if someone comes in with a gun, points at everybody and says, you're going to vote a certain way. And then they leave and the judge is like, you're going to ignore that. Okay. Well, how? How does that not influence you? And how much does it influence you? You'll never know. Never know. Chad Memes, member for 4 months, as Kurt isn't high functioning. He repeats too much.
For a minute that is an appropriate analysis of the law. whether I believe it or not is really irrelevant.
But why do you believe it, Dick? Are you just grounding it in fifis?
Don't
Because
say
that's
fifis.
I feel like. Are you grounding this in fifis? Make a legal argument.
Why?
It's structural. In the same way that the bribe is structural, this is structural.
There's the feeling that might be important is the feeling.
This part is really fragile, so be careful.
Okay, so my daughter engaged in arts and crafts time.
The top part's really broken.
I don't know if I'm like I'm going to prison, I think. I don't know. I'm trying to raise her right. So there you go. Thanks, lady. Yeah, have just message me about driving plans. So anyway, she's so funny. Literally, never tell her. She's the funniest person I've ever met in my life. What a disaster. She's going to ruin someone's life at some point. It's going to be great. I mean that in the best way. Okay. Where were we? Back
Structural. Why are you saying I feel this way? No one cares how you feel, Dick.
So the allocation of the burden of proof is not dispositive in your judgment. Even if it was erroneously assigned to you, you believe you met that burden of establishing prejudice because of the nature and frequency, the pervasiveness of these comments by the clerk.
If you use the analysis in both the Court of Appeals.
Kurt's now copying me drinking my soda. He's drinking from a water bottle, but that was clearly aimed at me, even though this already occurred. Okay, 4 minutes and 27 seconds on the clock. I'm going to refresh this because I want to get the live chat as it was. It was so where were we? So 4 minutes and 27 seconds, I think. Or no, it was. Oh my God. What is this? Here we go. Back to it. Now I can pull up the live chat. Why would it be there? No. Hold on. I think we can do that. There. Better. All right. Here we go.
Court of Appeals decision of Green, and then the Supreme Court decision in Green. If you look at the analysis, that's exactly what it is. There's not going to be any burden shifting or anything if it's innocuous, but if it is something other than that, then the burden does shift.
Is it innocuous or is it structural?
Shift to the state.
Is it burden shifting or is it structural?
It could be both. It doesn't have to be one. Anonymous sends, it was a sweltering summer of 2002, the summer they fired Opie and Anthony. Kurt began stretching my holes systematically. He hasn't stopped. All right. So thank you for that. Please go sit in the back of the bus, Rosa Parks. It is February, after all.
And we've met our burden. There's no second. She had a two-prong test. Second prong was,
I'll give you two prongs.
Did it affect the verdict? Well, I mean, if somebody that can't work for Rule 606B for one, but more importantly, you're asking jurors.
Correct.
Okay, we got to look at Rule 606.
We got to look at Rule 606B right now.
Hold on a second. All right, what is Rule 606? What does it actually say?
The Zeke says, Anonymous really knows how to paint a picture, a horrific picture. And of course, that's a perfect time to remind you that we do have pictures available now on Super Tips. In case you missed them earlier, we have pictures like this one, which I still legitimately don't understand that picture, but we do have that one. We have other pictures as well. Like me as an anime furry femboy, which you're just a day early. That's my Thursday. So we do have supertip.gg. You now have the ability to send in a picture. You can upload your own. You can also have the system generate an AI picture. If you don't have a picture and you believe you can adequately describe whatever disgusting thoughts are in your head.
What does the fox say? 606. All right. B. Inquiry into validity of verdict or indictment. Okay. Upon an inquiry into
Thanks,
validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations, or to the effect of anything upon that.
I'm going to read this because Kurt is incapable of actually reading what's there. So it's 606B, and here's what it says. Inquiry into validity of verdict or indictment. Upon an inquiry into the validity of a verdict or indictment. So if we have an inquiry, and we do in this case, right, we are asking whether or not the verdict is properly applied. If the jury was able to offer a fair trial and then make a fair decision based, on an impartial determination of the factual scenario and then the application of law to that. So upon the inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect. So first, no statements made during deliberations. The judge is not the deliberations are protected. They cannot testify to them. They can talk about what happened in deliberations on their own volition after the case, unless there's some sort of sealing order by the judge. But typically speaking, they're allowed to make statements to the media. The media is not allowed to approach them. They're allowed to approach the media. Typically, that's how we do it. But they're not allowed to testify to what happened in deliberations because, deliberations are complicated and there's arguments and there's opinions and those are all protected. And we protect those so that jurors will approach the process with candor, knowing that their statements and everything are safe and protected and they cannot be held to account for them by the court. Okay. So they can't testify to that or to the effect of anything upon that. So no effect of anything upon those statements in deliberation. All right. Very important. Or any other juror's mind or emotions as influencing the juror to assent or to dissent from the verdict or indictment, or concerning the juror. So that's another one. So another juror's words and their effect on this juror. Can't do that. Let's see. Or concerning the juror's mental processes in connection therewith. So they're thinking about it in deliberation, their mental process, what brought them to the decision. They can't testify about that either. And we talked about this earlier multiple times. It's because they don't know. People don't know this stuff. You don't know why you want eggs for breakfast today. You don't know. You don't know why you want blueberry pancakes tomorrow. You don't have any idea. You just do. Except, there's an exception, of course, that a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. So they can't do it by affidavit or declaration either. But importantly, they cannot testify whether any outside influence was having an impact on them or anybody else. All they can testify is, was a statement that was improper made? That's it. Because that's all that matters. If improper statements reach the jury, mistrial. That's it. Because the taint is supple and touchable. The taint is unavoidable and immeasurable. And fairness is obliterated. And there's no way around it. There's no, well, our fairness is only partially impacted here. Nope. Nope. He has no idea why this is. Like, he doesn't get it. He's not going to understand the rule. This is Kurt. Kurt's supposed to be good at this part. Like, this is the thing. He doesn't get it. Keep reading.
Or any other juror's minds or emotions as influencing the juror to assent or dissent from the verdict or indictment concerning juror's mental process in connection therewith, except the juror may testify on the question of whether extraneous prejudicial information was improperly brought to a jury's attention,
Facts.
or whether any outside influence was improperly brought upon a juror. No or may a jury affidavit or evidence of any statement by a juror concerning a matter about which the juror would be prejudiced from testifying for receiving these purposes. Well, I'm not quite sure what this clause means.
To the effect of anything upon that. That is describing the jury's deliberations, or the, and the statements that occurred during jury deliberations. That goes back to that part of the sentence. So I don't know why he doesn't understand this. It's basic English.
A juror may not testify to the effect of anything upon the jury's deliberations. But this isn't going to jury's deliberations exactly. A jury's minds or emotions. And then there's this big except clause, which seems to undo the whole thing anyway, in this context. So, yeah, I'm not. First of all, I think you might be able to ask about the jury. So the way this rule reads,
no,
the way the rule reads, it seems to imply,
no,
or seems to say, because we're going to the validity of the verdict. It's like you can't ask about anything that went to your mind or emotions or mental processes or deliberations, except that you may testify as to external prejudicial information.
Yes. Was an improper statement made? Was it accessible to the jury? Not, how did it make you feel? That's it. It's all. This is the funny thing, because this is where Kurt should be good at this. This is mechanical. This is not based on human emotions. This is not based on anything other than, did X occur? If yes, pass, go. You made it. That's it. But you don't get to ask about this other stuff because we can't measure it. It's not empirical.
And then the judge is asking as to whether or not that had any substantive effect. And so the way the rule's written, I think that's permissible. But I think that's permissible. So yeah. Okay, let's listen to some more.
To unpack for you what influenced their verdict. How did they get there, which you can't do under 606B, and people can't do, period. I mean, if somebody had walked in there with a gun and threatened everybody, and then left, and the jurors were polled a year later saying, no, I thought the evidence was overwhelming. It didn't matter whether somebody walked in with a gun or not. And overwhelming evidence is not the standard.
I don't know, man.
No, Overwhelming evidence is not the standard. Any improper statement accessible to the jury, tainted. Touch me, baby, tainted love.
I don't know, because you're talking about an external influence.
Don't touch
did it have an
me,
impact or didn't it have an
please.
impact?
I cannot stand the way you tease.
Yeah, I don't know, man. I don't know.
This Sixth Amendment.
I'm not sure the rule is clear enough on this issue, to be honest.
I was going to go somewhere historical.
I'm not sure the rule is clear enough. The rule is very clear. You can testify to the occurrence of a thing, but not its impact on the mental status of the jury during deliberations. What are you talking about? By the way, an improper statement made in week 1 of the trial can have a impact at deliberation. And so it's not when the statement was made. It's just, was it made during the course of the trial itself, or during the impropriety window? And improper has a lot of things. Like, that statement could have been made by the clerk of court prior to the trial starting. For example, if it was made during voir dire, during jury selection, or some other thing, and it became accessible to the jury. It's not just if it happens in the courtroom, blah, blah, blah. But the fact that these statements are made in the courtroom by the clerk of court on days where that information is being presented to the jury and is unduly being presented to the jury, then what the fuck are we even doing here? Why is it taking so long?
Do that. But yeah, I am. The Sixth Amendment was based on, as you know, English common law.
Yes.
In the trial of Aaron Burr in 1807.
Okay. All right.
For treason. This is not for killing Hamilton. This is for trying to sell part of the United States to Mexico.
I didn't know Aaron Burr did that. Also, based is very fucking funny. But what a treasonous monster.
He was a piece of work.
He was.
Sure.
Chief Justice Marshall quoted from.
See, like, I watched Hamilton too many times. I'm like, I like this Aaron Burr guy. Like, he's cool. He's I like his songs and stuff. I mean, he's a very talented musician. He may have been trying to sell part of the U.S. to Mexico. That wasn't in the show. It's not in the play. Like, so I don't believe it.
From Lord Coke, or Coke.
The best Lord! Whoa! Where's that guy?
Who said, a juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial.
Lord fucking
This is
Coke.
true regardless of the heinousness of the crime charged, the apparent guilt of the offender, and the station in life which he occupies. You can't say it any clearer, and that's what the Sixth Amendment guarantees. And that didn't happen in this case.
We understand that everyone, regardless of the heinousness of the offense.
I love that all these guys, all these guys sound like they're delivering their arguments from a fucking pro shop, and they're like, come on now. We got the heinousness of the offense, and the real offense is you're still using Callaways.
The character of the accused or the apparent guilt of the accused in no manner diminishes.
The Squid Pro Quo and their viewers have just joined. Hey, what's up, guys? Welcome. We are watching a much worse dressed lawyer improperly analyze a Supreme Court, a South Carolina Supreme Court oral argument. So welcome. We're doing legal stuff today as opposed to the illegal stuff that we normally do on the channel.
Diminishes the right to a fair trial.
Is this really the best South Carolina has for the top bench? These questions.
And this is where we get Kurt's hallmark. I would be so much better on the South Carolina Supreme Court. Oh, okay.
Half of these questions,
All right,
even the
Kurt.
ones, the way they're phrased, is
Man.
not really at the top of the tip of the spear, man. Are these really the best lawyers South Carolina can find, man? I don't know, man. I don't know. This is a little rough, man.
Some of us like it rough.
In your effort to set up that this is a man for all seasons moment, we understand the gravity of the situation.
Who is he
and the
justifying
entitlement
himself
of
to
every
right now?
individual to a fair.
He's not justifying himself. Again, what? How do you get through a grocery store interaction? I don't get it.
Impartial trial.
Oh, probably DoorDash.
Your Honor, I never doubted that for a moment. I think I was saying that more from me than you, because it's such a great quote. And again, came up during Aaron Burr's trial, who's such a terrible person. But even he was entitled to a fair jury.
And if you're going to go this way, you know what?
and here's what we're going to do. Kurt's going to say how he could have done it better and be wrong. Notoriously and obviously wrong. CDZ 9000 member for 8 months says Kurt's unearned confidence is annoying. Just wait. Just wait. He's going to tell us. And here's what Harpootlian should have said. And you're going to sit there and, well, I assume, maybe not. Maybe I'm wrong. But I assume you're going to go, why would that have been a better thing?
What would be even better? How about, when the redcoats were defended by Jefferson? No, it was, hold on. Don't tell me.
Jefferson defended the not black coats.
Adams. Yeah, it was Adams. Yeah, when Adams defended the redcoats at the Boston Massacre.
Yeah, that's way better.
That's the better example. Yeah.
Why? Why is that a better example than one of the, than someone tried for literal treason, murdered an American icon, and was again trying to sell bits of the United States to Mexico for personal gain. Insane to do that. Aaron Burr was a complete scumbag. Like, when you really get down to it, the guy was a menace, and he was afforded a fair trial, or, well, I mean, like, at least that's what we're led to believe as an Aaron Burr truther and family defender of the Burrs. Personally, I know what actually happened, and I know it was John Quincy Adams being a Ponzi little whore that caused all these problems. But that being said, Aaron Burr is a fantastic example, and defending the redcoats of the Boston Massacre really isn't that great of an example. I don't understand why that would be better. It's also a longer story, doesn't have the same oomph and character of because we don't even know their names, Kurt. I mean, somebody does somewhere knows their names, but everybody knows Aaron Burr's name because he raps now.
Yeah. So how about that? That's even better. Yeah. Let's do that.
We quote in our brief, and I want to.
I'm not as smart as Kurt in a field of beef. Actually, that's not true. That's not true at all. I understand meat way more. Probably the homosexual. Treasure Island says, to be fair, I could be a gold medalist in my mind if I tried. Just like Kurt knows better than these working lawyers and judges watching from home. And like, look, I'm not gonna say that a lawyer watching from home can't know better or can't point out some flaws here. But Kurt doesn't seem to be even considering the possibility that Harpootlian knows what he's doing, or that these Supreme Court justices have some sort of plan. He just doesn't even consider it.
Expand on it just a little bit. If you look at United States versus Elbaz, which is a Fourth Circuit case written by our own Jay Richardson.
The Redneck Hipster says, hey, now, John Quincy Adams is somewhere way back in my lineage. Put a little respect on his name. On his name specifically, John Quincy Adams. That's just amazing. Like, that they hadn't fully translated his name to John Sucks Dick Adams. Quincy, get out. I'm done with you. Not you. I'm done with John Quincy Adams. It's about time we got rid of that asshole.
He details what Remmer requires.
Who's that, Tom?
What the
Tom
to
Gillis.
trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous intervention. I submit we've done that in this case.
Yes, 100% I agree.
But the presumption's rebuttable. The government defeats the presumption by establishing there exists no reasonable possibility that the jury's verdict was influenced by an improper communication.
And just so we're clear, it's 2026. I'm not shaming anybody for sucking a little wiener. Who cares if John Quincy Adams did it all the time?
Which was not done in this case. And you should exclude, at least one, I would point out, Juror Z said it did. I mean, if we're going to go that way, now it may have been ambivalent. Judge Toll.
So now we do have one of the jurors giving an improper statement, but he is bringing up, the juror did say, yeah, it actually did influence me against him. But that statement needs to be thrown out and disregarded. It's not important. However, and this is where you get to one of those weird conundrums. Because the juror's self-assessment of the influence that it had on them, that isn't important. It's against the rule to accept testimony on that and to consider it. So that's the thing. But the fact that a juror has testimony about how it influenced them, the fact that the juror, the fact that the juror believes that these statements are improper, that in and of itself, that is not violative of the rule. The fact that this juror says, yeah, I heard these statements and these statements are improper. Now they need to strike. This is a judicial hearing, so it didn't really matter, but they needed to strike the juror's assessment of how it influenced them, because that's improper, right? Or the fact, and they can't offer the fact that they were influenced, but just that there was a statement that was made that could influence a hypothetical juror. That is the standard. That's what's allowed. And they have it. That the statement by that juror could be cleaned up, of course, if he was given a fair shake.
I said in the record, it can be both pressure from the jurors and what Clerk Hill said. But I don't think we need to go there, because 606B and almost all the cases about external influence don't allow you to ask the jurors questions about how they got where they got.
Part of Parker
because again, I'll say it because it merits repeating, jurors don't know how they made those decisions. No one knows how they make a decision. They can try, they can get close, but they can't know. They can't know what has influenced them entirely. It literally could be cracks in a sidewalk. They wouldn't know.
Versus Gladden was the Sixth Amendment was violated because the bailiff there who said this person's guilty, this wicked fellow, whatever, became a witness in the case. Is that what you're saying?
These questions are so casual. I'm just too used to Supreme Court. I guess I'm just too used to U.S. Supreme Court.
Yeah. So Kurt's got a I don't know how he's got this misunderstanding here, but he is looking, he's looking for the U.S. Supreme Court, which these are matters of law that need to be resolved because of either a circuit split or direct violation of the Constitution being alleged, or a conflict between states, et cetera, et cetera, et cetera. Either original or appellate jurisdiction of the Supreme Court of the United States brings very specific cases to its doorstep with very specific goals. They're not actually interested in resolving the factual scenario before them. They'll remand down once they resolve the legal issue. And so Kurt's like, I don't understand what's going on. Well, what you've got here is an argument that relies very heavily on a factual scenario that they can show occurred. That this pattern did happen. This fact pattern happened. And Harpootlian started off with it. He teed it up right at the beginning. He says, hey, in my 51 years of practice, I took my oath right over there. In my 51 years of practice, I've never seen a fact pattern like this. 20 minutes in, the man is closing out on the fact pattern. The man is closing. He's not making a legal argument. The legal arguments are pretty straightforward. If this thing happened, done. They're not resolving a conflict of laws here. They're not resolving an interpretation issue. All we need to know is, did this happen? Is there some reason that we need to defer to the court in their determination that these statements couldn't be admitted? And then also, was the court just fucking wrong in how it applied the law when it had its factual scenario? Those are the questions that are involved here. That's it. All this other shit, he's talking about the U.S. Supreme Court and how they do things there. And that's just lovely, but it just doesn't matter here at all. None of this is important to whether or not the state Supreme Court of South Carolina is resolving this case. All they care about is, did these things happen? Because they already know. They already know the legal issue. They're not trying to say, oh, well, what is this? I mean, there's a little bit of a disagreement over what 606B means to Kurt, but they're not calling up Kurt to try and figure out his opinion. They don't give a shit. They already know the rule. They understand it, and it's clearly written. It's obvious how it works out. Harpootlian cited a whole bunch of cases, and he says all of these cases, and maybe he's wrong. Maybe he's wrong, but it's pretty bold to stand before the Supreme Court and be like, all these cases stand for this proposition that you can't do this, and this judge did it. So that's it. There's not much else. So now the government, this is the burden shifting that Kurt didn't get. The government has to try to rebut the presumptions that are there. There's a presumption about what all this means, and now they get to try and rebut it. And it's going to be difficult, but we're not there yet.
Questions are so casual. They're so like, I don't know what to do with this. It's not the cadence I'm used to hearing.
He's sitting here saying that these judges don't know what to do with this. The judges do know what to do with this. That's the thing. That's where his confusion's coming in. He doesn't understand how people talk. It drives me fucking crazy. Kurt, they know exactly what to do once they have an appropriate factual basis. So what they're trying to figure out is what they can include in their review. What standard is it? Because if it's de novo, they include everything, like you said. But if it's not, and if it is abuse of discretion, and I think it is abuse of discretion, they need to figure out what facts are properly before the court. First question, first one. Can we include Egg Lady's testimony and statement? Can we do that? Harpootlian, I fucking hope so. I want you to do that. I will tweak your nipples if you just include that statement, because he knows if they include that statement, if they can keep in the record all of the statements by this bitch Becky, then they have a really good chance of getting this overturned and getting a new trial. Remember, Murdaugh does not go home. Murdaugh is in prison also for significant financial crimes in addition to the murder. That's a big problem here, is that he's also in prison, probably for life, but maybe he's got a chance of parole if it's just the financial crimes. The murder itself, he can beat the murder, maybe has a chance to get out in 20 or 30 years, something like that. Gonna be rough, but it's worth a shot. Plus, the general principle of, if he didn't actually murder his wife and kid, wouldn't it be nice to get a fair trial? Wouldn't it be nice to at least get a fair trial and try to say, I didn't do that. Like, and he's a huge fuck up. What, $50,000 a month in fentanyl? Massive, and probably a drug dealer, maybe a monster of his own right. But I still think, like, looking at the facts, I still have problems with the state's ability to prove this case. And I'm really curious what's going to happen if they retry it and he does get that fair trial, presuming he didn't get one, or assuming he didn't get one, or assuming that those statements by the clerk of court were sufficient to influence the jury. We don't know. And we can't know. That's why you got to do it over.
It's not the questions I'm used to hearing. This is like, Again,
This is how you practice law, Kurt. This is how you actually practice it. You got to get up and you got to build a narrative, and you got to tell someone that narrative, and that person is a person. That person is not ChatGPT. You can't just feed in a bunch of facts and law and citations and come out with some robotic answer and be like, wow, this is my brief. Like, okay, that's cool, but I'm not, hold on, let me rephrase that, because that was really unintentionally rude. I didn't mean that Kurt uses ChatGPT to write his brief. I want to be very, very clear. I don't think he would ever do that. No matter all the stuff I've ever said about Kurt, I don't think he would use ChatGPT to write his brief. I just meant that he uses ChatGPT generally, and he feeds information in and gets information out. It's something he's used to. I believe that Kurt personally writes his briefs. I believe that Kurt probably very, very thoroughly researches and reads the citations and makes them appropriately. I didn't mean to in any way. Like I will cast aspersions all day when they're proper, and that was a misstatement. I did not intend that in any way.
are we at a Supreme Court oral argument, or are we hanging out, at the 19th hole, drinking club after the?
Don't you want your lawyer to talk to the judges in South Carolina like he's hanging out with them at the 19th hole drinking club? Because that's what I want. I want that lawyer.
At the country club. What are we doing here, man? This is wild. This is so wild, man. Oh Lord.
And Clerk Hill became in this case?
Well, not necessarily. What I'm saying, Parker versus Gladden.
Marcy, you're not
you
even
only
living.
need 10 or 12 to get a conviction. And the Oregon Supreme Court said, well, we had 10 that weren't influenced by whatever the bailiff said. The Supreme Court said very clearly, doesn't matter. You're entitled to 12 impartial jurors. Also, that was the case in which the United States Supreme Court adopted, through the 14th Amendment, the 6th Amendment to the states. So that's the reason I like Parker, because it's got so many different levels that are very helpful in this case.
And in Parker, did it took 10 to convict in Oregon, right?
Yes, sir.
How about Judge Toll's finding that even if the state had the burden?
Time is up and everything, but we're just going to keep going, I guess.
Yeah, it's the Supreme Court. They can do whatever they want.
The clock means nothing.
It means nothing. the tism. No, there's a clock. There's a clock and it's out. There's a clock. There's a clock and it's out. What are you doing? You can't do that. You can't keep going. Can't do it. Can't do it. What are you doing? There's the clock and the clock's out. He doesn't. It's the state Supreme Court. Do whatever the fuck they want. The only thing they can't do is
why even
favor
have
one
the clock?
side.
She found any possible presumption of prejudice was overcome by the facts and the court's findings. She did conditionally rule that if I'm wrong about the burden, then the state has overcome that burden.
Well,
the presumption, excuse me.
Two things. One, she doesn't detail what that overwhelming evidence is. And you're going to hear from Mr. Griffin in just a moment as to how underwhelming that evidence is. Number one. Number two, that can't, the level of, if the level of evidence
help me
dictates whether or not you get a fair jury, then again, we go back to what Judge Marshall said. No matter how heinous, no matter how overwhelming the evidence, you're still entitled to a fair trial. I mean, if only the people that may be innocent get a fair trial, then our Constitution isn't working. I don't care.
Yep, 100%. You could be as guilty as hell. If you don't get a fair trial, how can we convict? That's the person who needs the fair trial. Like that's because that is the assurance that we need. And of course, that was the Aaron Burr reference.
I would submit this court shouldn't care. No one should care when there's a Sixth Amendment violation like Becky Hill committed in this case. And let me say this. I know my time's up. We spent months getting ready for this trial.
Harpootlian just told the Supreme Court of South Carolina to hold on a second. I know my time's up, but I got something else to say. He's already been talking 2 minutes past his time. And he still said, I know. Give me a minute. And that's because of how he respectfully built rapport at the beginning. He's built a level of trust with the judges. They know that he's going to close up his point professionally. He hasn't said anything superfluous or wasteful. He speaks slow. With a little southern drawl, right? But his cordial opening, which was soft on law, and not even that, really not even that hard on facts. It didn't matter, but it was still relevant, and it was part of the narrative structure, and it was obvious. He's built trust with them very quickly, and he's going to close it out. He's going to take a little extra time, and they didn't object in any way. Now, I'm probably going to press play, and they're going to say no and cut him off. That'd be funny, but I don't think so.
Trial. Weeks, 6 weeks trying this trial. More months finding jurors to talk to and find out if the court could talk to them. We had more hearings, more briefing. Nobody wants to do this again less than we do. But that's not the issue. It's not how much trouble it's going to be. It's what is Alec Murdaugh guaranteed to under the Sixth Amendment.
Thank you, sir.
Thank you, sir.
Excellent. Fucking closes it out really, really well. Harpootlian just delivered a really, really great 24-minute oral argument. And he hit the facts. He hit the law. He didn't focus on it. He didn't hyper attenuate it. He knows it's not an interpretation or a construction issue. He knows very simply, did these facts amount to an unfair trial? And can we bring these facts in? That's what he focused on. That's what the judges focused on. Let's see what Kurt's analysis of his oral was. Kurt, how did you like the oral that you just endured?
So I think the legal issue is whether or not this is structural. And
it's not a legal issue. There really isn't a legal issue other than the admission of statements. And do those statements amount to an improper, the ability to have an improper influence on a hypothetical juror? Whether or not it's structural or some other thing, the justice, when he brought up the structural aspect of it, he was merely condensing down and synthesizing the idea that that this thing is facially apparent and ultimately defective. That's it. That's all the matter of it being structural or not. It's facially apparent. It's ultimately defective. There's no foundation under the house. The house is going to collapse. If the house is going to collapse, we don't have a house. Same thing with the case. If you have these statements and they're made in the presence of a jury and the statements are of the character that would influence a hypothetical juror, done. And it's apparent. There's no need for statutory interpretation. There's no need for any interpretation. Do the facts line up with this obvious application of law? Because we care about fair trials. Like, do they do that? Do the facts line up? If the facts line up, mistrial. Now, the government has an opportunity to say, well, here are those facts, but we can rebut that, and let's see what they have to. We're going to have to do this later because I'm going to have to go for now. I'm going to have to go drive some kids around, but we're gonna come back either tonight or tomorrow. More of this. We're not done. We're not done. We got so much of this left.
Whether or not it is a rebuttable presumption, I think it's the legal issue, but don't quote me on that.
You're looking for something that you don't need to.
Good morning, Ms. Waters. Good to see you, sir.
Good morning.
That's it. Okay, so we're at the next part. This is where I have to wrap up. This is where I need to wrap up and call it for the evening. We need to do a member show. It does involve Kurt. Maybe some other people as well. And that's I got to see if we can do that tonight. Wednesdays and Thursdays, I always end up getting home really late, and I hate starting member shows so freaking late. I hate that. So I got to just see what my night looks like and see what I have available for, sort of this shell game of life. But thank you guys for joining me on these midday streams. I'm going to try, like I said, I'm going to try and get some consistency around these things because I got time during the day. Y'all got time during the day. When I have it, I want to make sure and get it out to you. There's tons to talk about, and there's tons of people to talk to. Upcoming guests, we're going to have Ron Coleman and Ryan Mullally on, two lawyers at different times, two different times. But we're going to have these guys on. Mullally is a guy who's been practicing law for a very long time, and he went to World War debate and mopped the floor with Pisco, which is hilarious, but also completely expected. The moment I heard that Pisco was involved in the debate, I figured he would be on the losing end of it. That's my personal bias against him because he's always wrong. So there is, that's good. So we'll have him on. Ron Coleman was supposed to be on Monday, but I had some personal issues. So we're going to reschedule that sometime very, very soon. Because I love that man. He's involved in some pretty important stuff. Litigating on behalf of people I like, litigating on behalf of people I don't like, because that's how lawyers do their jobs. And we need to hear about what's going on, because the issues that Ron Coleman deals with are the types of issues that we really, really care about over here. Let's see. With that, I'm going to play the short outro just because I need to get going. But thank you for hanging out with me today. We will very soon be back. I might even do another stream tonight. I'm not sure if it would be member or non-member. And I'm still working on the interview with Leslie and Michael Ferdarigos. That's the Lips lawyer. And so, once we get that locked down, I will let you know. All right, guys. I will catch you all later tonight, hopefully. Otherwise, very soon. Have a good one. Peace. So from the white shores of Nairn to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. I'm out here just trying to say peace twice like a normal human. But no. Whoa.